For yesterday, affidavit was
As
filed.
prayed for by Mr. M. Datta, learned counsel appearing for the petitioner with consent from the other side, relist after
I'm praying for 3 weeks.
3 weeks to enable the petitioner to file rejoinder against the affidavit in opposition filed
Lord, yes, day before yesterday.
day before yesterday, dated to be on so and so date by the respondent.
But it may be after 10th or 10th of
I'm
December.
not fixing any date.
Not-
Yes.
Blood.
May it please your lordship. My lord, as regard item number 18, my lord, we both joined together, my lord, to make a prayer, my lord. There have been.
You and
I'm not making it prayer.
I am making a
as
prayer.
prayed for by Mr. R. Dubey, learned counsel appearing for the appellant with consent from Mr. A. Dhar, learned counsel appearing for the respondent, relist
After 4 weeks, my lord, we
After
need to
4
file
weeks,
additional affidavit.
on a date to be fixed by the registrar to enable the appellant file additional affidavit as prayed for Visuddhaji Nalaga.
May it please your lordship, my lord, I beg to mention item 11 and 12 with the consent of the other side.
11 and 12.
My lord, comment side.
But I think 11 is connected with 10.
My lord, 10, I do not know how it is connected. My lord, it is not
No,
our.
but 10, where is Mr. Mondal? It's a connected case.
My lord,
So you have someone from his team as well?
no, my lord,
Because Mr. Counsel, in the cause list, 10, 11, 12 is shown as connected.
connect.
So if you are making a mention, then unless the counsel of for the item 10 is present, it will be difficult to accommodate you at the mention stage. I may accommodate you either when the matter is called or if someone from the other team is available right now. Yes, next matter, please.
Please, your lordship. Item number 20, lordship. I am on behalf of A. Acharya, lordship. He is out of station, lordship.
You are for the petitioner.
Respondent. lordship.
Respondent. Have you informed the other side?
Lordship.
As prayed for by
After 2
Mr. A. Acharya.
A.
Learned counsel appearing for the respondent with consent from the appellant relist after 2 weeks on a date to be fixed by the registry.
Obliged.
May I please, your lordship? I beg to mention item number 21, my lord. And for the appellant, my lord, I have taken consent, my lord.
You are for the appellant.
Appellant.
As prayed for by MS,
SSGR, my lord.
SSGR.
My lord.
Learned counsel appearing for the appellant with consent from the other side relist to the date on such and such date.
Maybe Monday.
Not this week, not the next week, after that date.
Obliged.
May I please your lordship? Lordship, in item number 42, lordship, an affidavit in reply has been filed by the petitioner.
Item number?
42 supplementary list, lordship.
Yes,
Kindly be called for lordship.
in item 42.
42, lordship.
Okay, call for.
Much obliged, lordship.
May it please your lordship, I beg to mention item number 22.
What do you want?
Your lordship, my senior, due to some personal difficulties, my senior won't be able to appear today. I beg to mention Passover for the day.
You are for the appellant.
Yes, your lordship.
You are for respondent.
No, lordship. no.
As prayed for, have you informed
Yes, yes.
Mrs. Esra? As prayed for by MS?
P. Thakuria,
P. Thakuria, Learned Counsel appearing on behalf of Mr.
P. Hajorika.
P. Hajorika. Learned Counsel appearing for the appellant with consent from the respondent to relist. Any other date?
Any date fixed by
It's
registrar.
a 18 matter at the date did job on such and such date.
On 21st.
May I please your lordship? I beg to mention item 31 of today's daily list.
30,
31, lordship.
31.
Lordship, we have informed by the petitioner that they wouldn't be able to appear to their lordship. And from the respondent, lordship may fix another date and matter be.
Where are the councils, HK Das and all, they are not in court. This is a very strange trend. Respondent informing that petitioner side has informed and making a mention in the court. Your name?
Lordship, I'm appearing on behalf of MM Rehman.
I am going to grant you the time, but with the caveat that if someone from the team comes and says that they have not asked you to make any mention, that this mention will get automatically cancelled to last till swimming pool. As prayed for by MS,
MM Rehman, lordship.
MM Rahman,
Lordship.
Learned Counsel appearing for the respond. Relist when?
Any matter. Lordship, the end of November, lordship.
Relist after 4 weeks on a date to be fixed by the registry. Yes.
Hello.
For admission.
With
Item
consent
number
from,
1.
with consent. Good. Yes, Mr. Roy? The ACR was not communicated.
Yes.
That case. Yes,
My lord, other day Mr. Roy, my lord, he argued that
you may take your seat.
because of the non-communication of APAR, that is Annual Performance Appraisal Report, for the period 2010, 2011 and 2011 to 2012. My lord, he is entitled to get the benefit of promotion. My lord, these two judgments I have gone through, it is not related with the case at all. My lord, I will take your lordships to the, my lord, first I will take your lordship to the promotion policy. Your lordship may kindly see at page 23 of the writ petition. Your lordship may look at page 24.
20?
Page 24.
Twenty-four.
The eligibility criteria.
Yes.
The officers intending to participate in the instant promotion process are required to fulfill the following eligibility.
Mr. Das? Mr. Das, I am not sure by what time your matter can be called, because it appears that there are at least 3 or 4 partnered matters. I don't know, all of them are fixed today. And in one, there is an MACT case.
Right.
Probably I shall take that first, because there already
Right.
everything is completed. I'm going to dictate the judgment. So I am not sure. And the other difficulty is that there are almost about 47 matters, and I'm working with a limited stenographer. There is the other one which I'm supposed to get is not there because of scarcity. And the other last working day, I've already dictated 2 judgments in the court, long judgments. They are still not being able to complete. I am indicating this is, I mean, it is not, you cannot do anything, but these are the practical difficulties also which are being faced this side because of scarcity of stenographers.
Can I paper pitching the matter that?
I
on
think
Tuesday?
that would be more appropriate.
Tuesday, my lord. Actually, today also I am.
You inform Mr. Chalia, because I don't want you all to unnecessarily wait, Mr. Das and Mr. Chalia, because I remembered I had said as first item of the hearing, I wanted to do that, but looks like 2 other matters have also got fixed as first items, and one already heard, the hearing is over. So it is only for giving the judgment. So you indicate, and you all will be accommodated. You just ask your junior to inform the court master along with Mr. Chalia's junior. All right?
My lord, I will take your lordships to the eligibility criteria. My lord.
Yes.
The officers intending to participate in the instant promotion process are required to fulfill the following eligibility criteria as on 1/4/2012. Now, in the left-hand side, your lordship will find promotion from SMG scale 4 to scale 5. Then the experience required 3 years. Then your lordship will see that the branch head exposure in the middle. The candidate should have been a branch head for at least 3 years. Then the relaxation allowed is for 1 year. The competent authority has allowed 1 year relaxation in minimum experience for the current process. Hence, all those officers who have completed minimum 2 years of satisfactory service as on so and so in SMG scale 4 are eligible to apply. The competent authority has allowed relaxation in exposure as branch head of the current process with the stipulation that such candidates who have not completed this mandatory requirement of being branch head for 3 years shall be given such posting immediately upon their promotion.
What do you want to point out from here?
Lord, I want to show that he will have to get through with
He'll have to?
the eligibility criteria.
Hmm.
My lord, your lordship, the precisely look at selection process at 4. The selection for promotion shall be made on the
Selection
basis-
process? Oh, yes, yes.
Selection for promotion shall be made on the basis of on-the-job performance and group discussion and personal interview. Only those candidates shall be called for group discussion and personal interview who have scored minimum 60% mark. This is important, my lord. In APA for each year of the years of service required for eligibility for promotion. Now here, my lord, in the 2 years, that is 2010 and 11, he got 59. 2011-12, he got 95. Nonetheless, my lord, in each year he'll have to get 60% marks. That is the eligibility criteria he'll have to get through.
No, that is his case.
Yes.
Because he was not given that 1 mark.
My lord,
He
I'll
should,
come to that, my lord, whether
that is his.
these two decisions of the appeals court, whether it helps him or not, I'll take your lordship to that. Then, my lord, your lordship kindly see
So
that-
page 24, you are only showing that minimum is 60% mark.
Yes, yes.
That is an undisputed
Yes,
position.
undisputed, my lord. But just I wanted to take your lordship to that. Then, my lord, your lordship kindly come to page 34, my lord. This is a judgment by this honorable court. At paragraph 4,
30?
page 34, my lord.
Yes.
Paragraph 4, my lord, I am reading. Thereafter, the impugned circular dated so and so that I had shown to your lordship
Yes.
was issued by the bank. With said circular, applications were invited from eligible officers for promotion from senior management grade scale 4 to senior management grade 5. It was mentioned that there were 43 vacancies in scale 5 subject to change. As per eligibility criteria mentioned, an officer in scale 4 should have completed minimum of 3 years of satisfactory service in that scale, as on so and so. And he should have completed a minimum of 12 years of service in the bank. The candidate should have been a branch head at least for 3 years. It was remarked that the competent authority had allowed relaxation in the minimum satisfactory experience in scale 4 by 1 year for the same process. Thus, all those officers who had completed minimum 2 years of satisfactory service, as in so and so, in scale 4 were declared eligible to apply. Moreover, only such candidates were made eligible to participate in the promotion process who had scored minimum 40% marks in computer literacy test organized by the bank through IBPS on so and so. As per 4.1 of the impugned circular dated so and so, selection for promotion would be on the basis of on-the-job performance and group discussion and personal interviews. Only those candidates would be called for group discussion and personal interview who have scored minimum 60% marks in APA for each of the 2 years of service. Now, your lordship will see at page the observation given by this honorable court at page 45.
Yes.
Taking the position and having regard to the law laid down by the appeals court, the following directions are hereby issued. Entries in the APA of the petitioner for both the years be communicated to the petitioner within a period of 30 days. Petitioner may submit representation. Then number 3, such representation of the petitioner shall be considered by the authority of the bank who is placed higher in office than the accepting authority. Considering of the representation shall be done fairly and objectively with an open mind. Then your lordship kindly see paragraph 4. Once, this is important. my lord.
If
Once-
attains eligibility.
Once the above exercise is completed within the period specified, and if petitioner attains eligibility, this is important, bank shall hold a review DPC to consider the case of the petitioner for promotion to senior management grade scale 4, along with the batch of so and so. Now, my lord, I will take your lordships to, my lord, the page. Now, this honorable court white judgment, the lordship has seen at page 45. Now, he has filed his, my lord, at page 56, your lordship will find, we have furnished the relevant page 56, my lord. That according in defense from there,
Page?
page 56. Accordingly, in deference to above directions of Honorable High Court,
50?
56.
Yes.
This is the decision of the appointing authority. Accordingly, in deference to above directions of Honorable Guwahati High Court, the bank has duly informed you entries in the FER for both the years, while letter dated so and so. Subsequently, you submitted detailed representation dated so and so to the Assistant General Manager inter alia with a request to forward the same to appropriate authority for upgradation of so and so. Please note that your aforesaid representation dated so and so has been placed before the executive director.
You're reading from, oh, acha, you're reading from here. Second paragraph from, third paragraph from the top.
Yes.
Accordingly in deference. All right.
Accordingly, in deference to above directions of Honorable High Court.
Yes, that I've seen. Now, please note that.
Please note that your aforesaid representation dated so and so has been placed before the executive director of the bank, being an authority higher in the office than the accepting authority, for the purpose of APR of officer employee working in scale 4, for taking a decision after consideration of the same in due compliance with the directions of the Honorable High Court. Accordingly, the appropriate authority has duly considered entries in your APR in original from so and so pertaining to your performance as an officer of the bank in different capacities, marks obtained against different sets under so and so, your achievements on various heads mentioned in APFs, your independent assessment of own performance during interim period, observations, special comments of your reporting, reviewing authority, against each entry appear at relevant point of time and after examining all relevant facts related to reporting of your work performance inter alia during the year 2010-11 fairly and objectively with an open mind and disposed of your representation so and so by observing as follows. I have seen past performance and performance in the branch. Maybe in the training college he has done good, but as branch head his performance was not so good and marks allotted are fair and without any prejudice or bias. Thus, with aforesaid observations, the appropriate authority has disposed of your representation dated so and so in terms of the directions of the Honorable High Court.
Yes.
Now, after that, my lord, he filed his representation, which your lordship will find it as page 84. That is, my lord, at page
Yes.
84, your lordship has seen that. Now, your lordship may see at page 55, we have adjudicated it.
Page 84 or 55?
84 is the representation.
Yes,
And the disposal of that is at page 55.
which you just read.
Yes, just I have read. Now, in view of such things, my lord, the non-communication of the ACL, it was at some point of time, there was some defect. He came before your lordship
That
passed an
this
order.
court has given him, and accordingly it was given to him.
Therefore,
Then he filed representation, you have considered.
now, and then again, my lord, he came before this honorable court.
Because
lord-
he says that the significant drop, according to him, for which he has lost one mark. His grievance is that basically because he was posted in such a area where it was difficult. And
That's it.
another, no, but I think that was his,
You want to say?
correct, that was his main thing, right? And it says very good, and then suddenly the marking is very less.
I'll come to that.
Correct, Mr. Roy, this was your specific.
I have something more to say also.
No, that's okay.
Okay. That is also definitely.
That
one of
is,
the
that is your main thing, that sits.
Now, here, my lord, it's a case where the annual performance report was.
Because whatever you just showed is all the attending facts. Till here, all these are all undisputed facts. That you have just placed these very facts which has a relevance in the matter.
Right.
Now come to the core issues that have been argued before the court.
Okay, I have been to your lordship these things because he has argued this non-communication of the ACL will give him a chance to give him a
That
promotion.
was taken care of.
Now, these two.
No,
decisions-
that can't be. Non-communication was on, the court have already adjudicated that part.
Yes, yes, so
And the
that,
court has already directed that you communicate,
Right.
you give representation,
Exactly.
after that you take a call. This has been done.
so.
Now the fact is whether there was any bias element or anything which he is now complaining, because this court is also mindful that this court is now exercising a very limited
Right.
jurisdiction. And this falls within the ambit of the discretion of the reporting as well as the accepting authority. If nothing malafide or arbitrary falls writ large, this court is not going to interfere into all that, isn't it?
Yes.
So now, therefore, keeping everything in mind, you respond to the main arguments that has been placed.
Now,
Because I remember there were some marking which was shown and a standard was shown, but that standard is only for the given for the overall assessment, not for those markings. That cannot be. But nonetheless, it seems from and a comparison was made from the previous years to the current year where there has been a drop. There has been a drop.
I'll come. to
So
that.
you come to all those. Those are his argument in the main case.
Yes. Now, in regard to, my lord, dropping of the marking, this has happened because in banking area, my lord, your lordship will find how we give the marks. My lord, assessment of an officer performing the role of incumbent in a branch is totally dependent on the achievement in the market. My lord, if there is a target and the incumbent is crosses that or does beyond that, my lord, he will get full marks to that. Now, this is one of the chapters which we are not concerned in this case. Our case is, my lord, assessment of an officer working in support role of a regional manager in the regional office, which is non-operating part. So therefore, his performance can be assessed only by the reporting authority. Now, the reporting authority knows what is his attitude, what is his behavior to the customers, what sort of work.
He's the
he's
best
doing.
person to judge.
He's the only and only the best person. My lord, I will take your lordship to appeals court decision right on that line. Appeals court has time and again said he is the best person because none other than him can assess his performance as an officer. Now, so for 2010-11 performance, he was, my lord, working as a support role of the regional manager. And he found that his performance is not up to the mark and therefore he could not get 60% eligibility marks. Now, in regard to, my lord, he is arguing that I got 95 in the next year. 95, what happens, my lord? His performance in training center, that can be assessed, my lord, based on the ability to impart training
In
my lord, in training center. He was transferred to the training center on deputation.
that was in which year?
That is the next year, 2011-12. There he did splendidly well, getting 95. Now, what he did, my lord, he used to impart training and deliver lectures. And he got 95. So therefore, these are all annual performance every year. Now, in one given year, we were in some area, you have shifted to some other area where you did very well. So therefore, one cannot argue that merely because I did in 2010-11 very not good, but in the next year I got splendidly well, getting 95 marks. That cannot be an argument that I should not have given 59. It should have been.
Here he was in the branch office, no?
No, he was working 2010-11. He was working with the regional office.
The year that we are concerned is 10-11.
10-11. We are concerned in 10-11. He wanted to upgrade that marking there.
So 10-11, he was in the regional office.
Regional office. He was doing support role to the regional manager.
Support. Basically loan.
All that, my lord, administrative works and all that.
Here he got 90. No, he got how much he
Yeah,
got?
59.
50.
That is his contention, my lord, and the contention in this petition itself is boiled down to that only. Now, so for the next year, because you have got 95, he cannot say that, I should not have been given 59. Because only the reporting officer, then reviewing officer, they found it is 59. So therefore, that cannot change the position. Because, my lord, as your lordship understand, as a lawyer, my lord, we have plenty of juniors. My lord, there may be I am having 6 juniors, but amongst them, who is the best? Only I am the person I can know. So similarly, my lord, the regional officer, he was working under him. And he knows what sort of officer how he's working and all these things, my lord. Now, possibly this is the area only where your lordship will confine. Now, if I take your lordship, the judgment cited by Mr. Roy, my lord, that is Abhijit Ghosh Dastida.
The written compendium was given, no, only the judgment was given, no?
Judgment copy is furnished.
Yes, once.
I'll read that. You will.
Yes. Para,
Paragraph 4, it is not in dispute that CAT Patna bench.
or which one? Avijit Ghosh
Avijit.
Dastidar?
Abhijit, yes.
You want to rely 4 and 5?
4 and 5.
Yes, please.
It is not in dispute that CAT Patna bench passed an order recommending the authority not to rely on the order of caution dated so and so and the order of adverse remarks dated so and so. In view of the said order, one obstacle relating to his promotion goes. Coming to the second aspect, that though the benchmark very good is required for being considered from promotion, admittedly the entry of good was not communicated to the applicant. The entry of would have been communicated to him as he was having very good in the previous year. In those circumstances, in our opinion, non-communication of entries in the SER of a public servant, whether is in civil, judicial, police, or any other service other than the armed forces, it has civil consequences because it may affect his chances for promotion or get other benefits. And such non-communication would be arbitrary and as such violative of Article 14 of the Constitution. The same view has been reiterated in the above referred decision relied on by the appellant. Therefore, the entry is good if at all granted to the appellant. The same should not have been taken into consideration for being considered for promotion to the higher grade. The respondent has no faith that the appellant had ever been informed of the nature of the grading given to him. Now, counsel appearing for the appellant has pointed out that the officer who was immediately junior in service to the appellant was given promotion on so and so. Therefore, the appellant also be deemed to have been given promotion from 28/8/2000. When the appellant had retired from service, we make it clear that he is not entitled to any pay or allowances for the period for which he had not worked in the higher administrative grade group A. But his retrospective promotion from so and so shall be considered for the benefit of refixation of his pension and other retail benefits. Now, so for the factual aspect, my lord, there is a C difference between the two pieces. Here, my lord, ultimately there was a defect, then your lordship passed an order. Accordingly, we have given the entry in the SCR and all that. He replied, and then we have given a reasoned order. Secondly, my lord, the petitioner has retired way back in 2022. Now, therefore, so for the question of promotion at this stage, it will not come at all.
Question of?
The question of promotion doesn't arise because he's retired long back. That is the 31/1/2022. My lord, I have a decision to that effect. I will cite that one also.
No, that will only arise if this court finds that the marking is.
My lord, only.
Why are you going to the, do you think the defense is weak?
No, no, not
Then,
at all.
then why, first, what about the marking? What, you said you have some apex court decision?
Yes,
Give me that.
my lord,
Why are you going to all those aspects
Yes.
unless you've already given up your case on it, huh? That comes only, it's a consequential. Once if this court finds that the marking is wrong, then the question will come, what is the relief to be given?
My lord.
Yes, let's be focused on the core issue first.
My lord, I'll be reading a paragraph 147 of a decision. My lord, I have one copy. After reading, I'll hand it over to you, lord. My lord, this is 2011 10 SCC, page 1. In paragraph 147, writing the confidential report is primarily and essentially an administrative function Normally, tribunal courts are not to interfere in.
Normally,
Normally, tribunal courts are allowed to interfere in cases of complaints against adverse remarks and to substitute their own judgment for that of the reporting or reviewing officers. It is because these officers alone are best suited to judge the qualities of officials working under them and about their competence in the performance of official duties entrusted to them. Despite fear of abuse of power of prejudiced superior officers in certain cases, the service record contained in the confidential reports by and large reflects the real personality of the officer.
real?
Personality of the officer. My lord, Your Lordship,
No, but where does it say? I'm sure there is a caveat also that in a situation, in what situation can the court interfere? That part is not given.
That part it is not highlighted. Well, this is.
It is not going, it is not I'm sure there are situations where the court can also interfere. So,
That facts of each case will decide.
correct. I think one or two decisions you have given.
Yes,
So you have to distinguish those also.
He's made these two decisions where he want.
No,
want
he
to
has
say-
given 6 decisions in
Six
total.
decision. Moreover,
Yes, number one is that Manoj Kumar, which he says molding of relief. Then number two, sudden fall of marks without justification.
Yes,
That
sir.
is Delhi. Then these are marking.
certain fall will not
Then that you have said it, but what about that decision? And then another one on a similar line is again from Delhi, Ajit Kumar, correct, Mr. Roy?
Yes,
That's on a similar line. Similar again, another Manudev Dhaya, Delhi. These are on similar lines. Then 5, of course, is an uncommunicated ACI, and that perhaps and the residual part. But that, of course, is communicated. This is Apex Code, I think, isn't it?
Yes, sir.
Apex Court. So these decisions, what you have to say?
My lord, the
That is, of course, the law. And therefore, I think I also opened up saying that this court is exercising a very limited jurisdiction because at best the reporting officer is the best judge. But nonetheless, if the court finds that it has been done in a very arbitrary manner, now
Yes.
now this arbitrariness has to be something very you see, it cannot be some on an objective basis. It has to be something which can be writ
Very-
large or
very
or
striking.
very
Yes.
striking. That's the word. I'll hear you. You'll have a chance to reply.
My lord, then my lord, he has.
One sec. You
Imputed-
want water, Mr. Datta, Mr. Roy?
No, it's all right. Thanks for that.
Yes.
Then we going to find that page 12 of the
Where
petition.
decision you relied? Is this Rajendra Singh Verma?
Yes, yes.
This one. Which was that paragraph?
There are 147 that marking is there.
140?
147.
I'm going to borrow this.
Yes, sir. For me, lord.
Was one leg of your argument also that that ACR was not communicated that adverse?
Yes, Lordship, I was disqualified on the basis of.
Oh, but subsequently it has been
After
communicated.
this order was.
Correct. After that order it
That-
was
it has
given.
been-
So that means that doesn't hold good right now because that has been already communicated.
So my,
And it has been taken care of the court's order. And
Yes,
to
yes.
which you have filed a representation and they have also considered.
Right.
That may not be to your satisfaction, but nonetheless, that exercise has been done. So no
My-
prejudice is caused.
my.
No, I'm just trying to understand.
Yes, yes.
Otherwise, you see these decision of the court will have no meaning
Exactly.
because by that decision, nothing was interfered, only communication.
Yes,
Now,
yes,
communication has been done. Okay. See, this is what, you are not, Mr. Datta, 151, 150, these are also relevant paragraphs of your decisions. What is relevant to notice is that this court has held that an uncommunicated adverse ACR on record can be taken into consideration, and an order of compulsory retirement cannot be set aside only for the reason that such uncommunicated adverse entry was taken into consideration, uncommunicated. If that be so, the fact that the adverse ACR was communicated but none of the appellants had an opportunity to represent against the same before the same was taken into consideration for passing the order of compulsory retirement cannot at all vitiate the order of compulsory retirement. Instead of so-and-so versus so-and-so, this court has ruled that before exercise of the power to retire an employee compulsorily from service, the authority has to take into consideration the overall records, even including some of the adverse marks, which though for technical reasons might have been expunged on appeal or revision. What is emphasized in the said decision is that in the absence of any malified exercise of power or arbitrary exercise of power, a possible different conclusion would not be a ground for interference by the court tribunal in exercise of its power of judicial review. That is also the ratio held in this decision that you have given. According to this court, what is needed to be looked into is whether a bona fide decision is taken in the public interest to augment efficiency in the public service. So that is why I'm saying this court is not completely barred to go into it, but only in a situation where the court finds that yes, there is mala fide, proved, pleaded and proved. In those situations, and that the decision was not taken bona fide. Here, of course, nothing such has come except a guess that in 2010, 11 to 12, he got 95, and here he got 59. Therefore, there is a huge difference. Only that part. Apart from that, I don't think anything else have come on pleadings. As far the mala fide is concerned, because mala fide has to be pleaded and the concerned officer has to be arrayed as in person. That has not been done, right?
This is also one of my argument. In paragraph 12, your lordship will find, he has stated that petitioner was allocated 59 marks with a preconceived mindset to eliminate him from the promotion process. Now, in that
That's vague.
that view of the matter, my lord, he ought to have made the reporting officer as a
That
party.
is not done. That's why I'm saying mala fide is not pleaded as such.
Not pleaded, and even if you plead, you haven't.
You haven't made the person concerned a party.
My lord, to that effect, there is.
That predetermined mind is only it's a very
That's the-
general, vague,
Very, very, very.
very
general.
vague, because there is nothing to show. A reading of that, it seems there was a reason. There was a reason.
Pleading to that extent is.
Where is that page? Where is that page? There was
That's,
some reason given.
Yes, page 12, you'll find.
No, in that concerned ACR report, where that adverse thing was there, paragraph, I think 53 or
What, that report.
for that year. 2010-11, 49.
49.
49. We are concerned with which one? Leadership.
Yeah.
Are we concerned with leadership?
He want to say, my lord, in all this, right from the key responsibility area, he want to say out of 20 has got 13.
Where?
It's page 49.
Yes.
This is the key responsibility area.
Quality of performance.
Quality of performance.
Very good, capable of executing, discharging the job independently, does not need much supervision, but
My lord, can I make a request? My lord, AC is a bit troubling me. My lord, if it is tuned down a little bit.
sorry? Of course, I keep telling them all the time. What happened is that because I keep going into the briefs, I forget. Later I catch a cold. And I tell them that if you put it in the at a higher temperature in the beginning, then you put it little lower later, but they just don't control it. Control কৰি দিলে হয় একদম 25-26 তাৰ ফেনখন low কৰি দিয়ক এতিয়া অকমানি বন্ধ কৰি থওক অলপ কমত দিয়ক. The problem is, Mr. Datta, what happened is that after a point of time, again, the code becomes very suffocated.
Then they can make it.
And then that's why the best way is to control it and keep it in a low temperature.
They don't have any-
I don't know. The other day also it was very difficult.
I did assure it will.
No problem.
And your lordship has seen that
But needs more
penetration
penetration
in tackling,
in
tackling
tackling defaulted borrowers
of
of
all
all segments. And this part of the observation, in fact, is admitted by the other side.
Yes.
Yes, there was this difficulties
Right.
because of these hurdles. That much is also admitted. So it is what he has understood. And out of 20 is given 13. And reviewing authority has accepted.
And then again, your lordship will find quality of judgment and decision satisfactory, sometimes apprehensive, for which.
So there are
Result-
reasons.
Now, these are, my lord, with good reasons, my lord, the
Mhm.
marking was given. Now, if anybody want to say it's arbitrary,
And then reasons, constraints for not performing well, vulnerability of area, very poor asset disposal, scope in villages, though in sensitive areas, some success could be achieved.
Semi-urban areas, not sensitive, semi-urban areas.
Semi-urban, semi-urban, sorry. This part, can you again, Mr. Datta, can you ask Junior to give it in typing, if she can
yes,
type it
yes.
out? This
I'll
part,
I'll do that.
because it's very difficult to read
Yes,
from
yes.
here. I may have to quote them in the judgment.
My lord, I'll do that.
Specifically, this part, the quality of performance, the responsibilities allocated, reasons, constraints for not performing well. And then there was another thing, I think.
Your lordship, managerial dimension at page 51.
Page 51, yes, leadership. Leadership, integrity, and then no other view. And out of 8, 10 was given. That is what you have said, no, in this?
Out of 8, only 3 months. That's
Out of 8, out of 3.
37%. That comes to 37%, which is below average.
No adverse view otherwise.
No adverse view also.
Okay.
But it's specified in the format itself. Reason has to
Okay,
be
and this,
specified.
Mr. Datta, I think that day only you clarified that leadership is not just integrity, but it is also it's a combined thing of all these 1, 2,
Yes.
3, 4, 5, and together out of 8, 3 is given.
Comes under.
So adverse remark is only in view of integrity,
Yes.
not the others.
Petitioner tries to persuade your lordship saying that the tick mark part is integrity.
Correct.
honesty,
I
integrity.
remember that day only you
correct,
had
sir.
clarified this.
Your lordship will find others.
No, I remember. You don't have to repeat.
Well,
I remember you clarified
Yes,
that day
yes,
only.
I'm so obliged.
Yes.
Now, these are the things, my lord, I'll get it typed and I'll submit to your lordships. Now, so far, these are the things your lordship will find. at page-
Also, please give a copy to Mr. Roy.
Yeah, surely.
I've asked them to make the typing because the juniors are there. I didn't want to trouble you, Mr. Roy. Yes.
I'll give him. a copy. Now, therefore, my lord, your lordship has seen at page 53, the total marks he got 59.
59.
I'm very sorry that 1 mark short, but then he has missed the bus. And my lord.
And these are the overall assessment. This is the reporting officers, self-appraisal, reasonably accurate, training needs, accurate. The apprentice is a trainer now.
Appraisee, lordship.
Huh?
Appraisee,
Is a trainer now. Correct?
trainer now, so
Hence,
hence no need for the training as sought for. So they are so much of convinced about my quality that they suggest no further training for me. But they are
this is
disqualified.
this first noting is by whom? By the reporting.
By-
And the reviewing says agreed.
Agree.
Yes.
my lord, these are the things, my lord, this part, My lord, unless it is strikingly visible arbitrariness.
The reviewing authority could have added 1 mark, he would have got it. Now he's missed the bus for 1 mark.
Had I been there, my lord,
Same here. That's not what the reviewing authority could have. It is not that this is a case where he's been underperforming. In fact, to be fair to him, because he was working with constraints.
that's
That's
true, my lord,
that is
but
an
then-
admitted fact. That's an admitted position.
That's true, my lord.
Where
but
he
then
was, that is why I'm saying, I'm not saying give him 100.
what was,
You
your-
see, very good is 70 to 85, and what you have given him is good. That is 55 to 70. So if you have given him good, marking could have been 60,
But,
not 70.
what it was working in the mind of the reporting officer, my lord, he's the best just to.
No, I'm not, you see, reporting authority is okay. Now the reviewing authority is not some post office.
Yes, yes.
The job of the reviewing authority is not a post office job, isn't it? Otherwise, why there should be a reviewing authority or an accepting authority?
My lord, this is.
They are not mechanical.
This is one of the part, but
No,
then.
I am just saying it. It is not a mechanical exercise of mind. It has to be done in a reasonable, fair manner. This is why so many checks have been given, because these reports, this assessment ultimately has, it may prejudice the service future prospects. So it has to be done with some reasonable care, isn't it? That is why these checks have been given. So the reviewing authority, sorry, he simply agreed everything. When the overall assessment in the tick column, it is ticked on good. The standard marking is 55 to less than 70. Yes or no? So if you or I was here, we could have said that since it is good, therefore we enhance 59 to 60 or 61. Yes or no, Mr. Datta? No, ideally, isn't it? He's been deprived of a promotion. The promotion benefits.
Can you say on his part, that the promotion drive was in the year 2014.
That time,
He-
this adverse communication was not communicated to him.
Not that I'm on another line, my lord. And he retired in the year 2022. What stopped him to sit for this promotion? drive
No,
once
he
again?
came to know later, right? When did you come to know? When did you have this knowledge?
About this API.
Uh-huh.
This was only after I filed this first writ petition in,
So that is the time he came to know.
I'm not on that, my lord.
Then?
I'm saying that he could have gone for a promotion drive in the next year also.
Why?
From 2014 to 2022, there are so many occasions came, he did not go for. all
yes,
that.
Lordship, I will reply if I may.
You will get your chance to reply.
So therefore, my lord, he never tried because
Sorry, Mr. Datta, I could not understand. I'm sorry, I'm not being able to appreciate this part of your argument.
regarding, my lord, it's a different line. If he really wanted to go for, my lord, promotion from scale 4 to scale 5. Now, the next so many years he could have gone for it. He opted not to go for it. So therefore, the problem lies with him also. And my lord, the reporting.
Okay, I need some more decisions on the role of the reviewing and accepting authority in such matters. I'm sure you will find something more.
Role of the reviewing authority.
Whatever be it, against you, in favor you, place it
Yes,
before
yes.
the court, Mr.
No.
Datta.
Our duty is to assist your lordship. my lord.
You see, because it's a 1 mark, and the good is the standard marking is 50 to less than 70.
Now, supposing, my lord.
I am also mindful that otherwise there is no mala fide, pleaded, proved, arbitrariness, otherwise is writ large. I'm aware of that. And this is purely the discretion of the reporting authority, marking and all, reviewing authority. But what I am on is the reviewing authority has also a duty.
Yes, yes.
So onto that effect,
No,
if something,
Keeping back in mind that aspect also, my lord, your lordship can see whether he has the right to get promotion at this stage.
that is a different thing. You're again going back to promotion. We
That-
are not going to promotion, right?
I started that.
You see, if we find that he would have been eligible, then of course all the benefits coming with that promotion may be given to him. That is a different thing. Let us not go to that aspect, whether that can be given or not. First and foremost, whether this marking
Role of reviewing authority.
was correctly done or not, because that is the main subject, core issue in this writ proceeding. Depending on the answer of that issue, the consequential actions will come. What reliefs to be given, if that is in affirmative, the first answer, isn't it?
That's true, my lord, but then what I understand that even in such eventuality, your lordship can go for national promotion, if your lordship think at all.
See, again, you're on that.
Yes.
Mr. Datta, let's not get into that aspect
Yes.
right away. I'll give you time, a short time. You find out about the reviewing authority.
Yes.
You'll
The power of
find
the
out
reviewing authority.
power of it in such matter. Because I'm sure
I'll
ultimately
look into
this
that.
court is exercising the writ jurisdiction, isn't it?
Yes.
It doesn't look, after going through all this, it doesn't look something right as far as the reviewing authority is concerned. Yes, I don't find the reporting authority's markings to be unfair. He's fairly marked it at the end when he calculated he may have got 59. These things happen.
Yes.
He was not giving the marks thinking that I'm going to make him 1 mark short. Otherwise, he would have given reporting only in that manner, you know. So of course, I don't doubt his intention. I'm not saying he's not being he's being mollified. I'm not saying that. But then the reviewing authority, he have seen 59. He knows the eligibility mark.
Possibly in his best assessment.
You see, no, but he have also seen this reports that but areas more penetration in but needs more penetration in tracking defaulted borrowers of all segments. Now, why? Because of that vulnerability of area. Because of vulnerability of area. Very poor asset disposal scope in village. Though in semi-urban areas, some success could be achieved. So, you see, reviewing authority has to also apply his mind. He can't be adopting a very mechanical approach that, no, I don't see anything arbitrary. It's not about the arbitrariness that he is going to review of. He has to see whether the marking has been fairly done or not, whether it has proper or not. Because this is ultimately a discretion, right? I'm on that. Please find out. I'm sure you will get something.
I'll see.
Huh?
Yes.
Mr. Roy, you save your energy for the next date, because let's see what comes, and then in the final reply you give your reply. And in case you want to make a 1-page submission summary, you're at liberty to do that. You are also. But when do you want it? Next Thursday?
Lord, next week, possibly my availability.
When do you
is
want
not-
it?
After 1 week, my lord.
Give a date. We both have to be there. Mr. Roy, when can it be convenient after a week?
I am free, Lordship, because I am a retired
All right.
person, anytime.
Heard, Mr.
Lordship, may I please, just I want to respond to 2 issues here.
Not today, Mr. Roy. A lot of other matters are also waiting. As we are not going to logically conclude this matter today, then it doesn't look
Yes.
good of by investing more judicial time in this matter today.
Lordship,
I shall give you that time when at the appropriate day. Let the other side first finish. You will have your right to reply.
My-
Yes.
Can I suggest a date, my lord, 17th November?
Is it okay?
Okay.
17? Heard Mr. Debashish Royal, petitioner in person. Also heard Mr. S. Datta, learned senior counsel, assisted by MS S. Mushahari, learned counsel for the respondent PNB. Stop. Mr. as Datta Lalit Senior Counsel has partly concluded his argument. However, in response, as the role and power of the reviewing authority in reviewing the assessment of the reporting authority in the AP annual APC, how it is called APAR, in the APR, comma, he seeks a short accommodation to reply in this regard. Relist on such and such date for further hearing.
17th.
And on that day, please give your short note. Huh?
Obliged.
Yes.
Item number 5.
Yes.
Lordship, kindly adjourn the matter for the day. Lordship Senior is out of station because
Right.
unexpired.
As prayed for by MS.
A Das Lordship.
A Das, learned counsel appearing for the petitioner on the ground that the leading that the arguing counsel, Mr.
A Charlie Lordship.
H. Ali, for the petitioner is out of station. Prayer is not objected. Relist when do you want it?
2 weeks Lordship.
2 weeks?
No, my lord,
When do you want it?
after 1 week.
Okay, after 1 week on a date to be fixed by the registry. Yes.
Number 6.
He's not a regular here. If he wants a date, please DD after a week.
Maybe little lordship.
Yes.
Conducting council is Lakes in Undercourt lordship.
Huh?
Conducting council is Lakes in Undercourt
All
lordship.
right, next week. Let's pray it for next week. When do you want it? Wednesday? Next
Lordship.
week?
Deplore.
7 to 9.
Disciplinary proceeding, memorandum of charges.
Yes, my lord.
You are Mr.
Tapas Das.
T. Das.
Yes, my lord.
Who is for the other side?
Mr. Goswami,
Where are they? You Goswami. Mr. Das, respondent side is not there, but I think pleadings are complete.
my lord, pleadings are complete, my lord. If my lord took up the matter in last date of hearing, and the one petition from the Itanagar bench, my lord, it has reached and numbered as item number 9, my lord.
So it is there today.
Yes, my lord.
All the 3 cases are before this court.
Yes, my lord.
So we
I do
can,
not know whether in
Mr.
number 9 they will file CA or not.
But they are not here, so either I adjourn it on another date or I could have
First of
otherwise.
December can be given. my lord.
Okay, okay. Heard Mr. T. Das, learned counsel appearing for the petitioner, senior counsel.
No, my lord.
For the petitioners, also heard, none appears for the respondent CGC on call. It appears that the WPC 482/2000 of 2024, which was called for by this court earlier, has also been received and is tagged along with the present set of writ petition as item number 9. Relist on such and such date. When do you want it?
1st of December, my lord, but the interim order to continue.
Interim, if
Both the-
any, shall continue till the next date of listing.
Deeply obliged.
In 9, you are only the petitioner's lawyer, no?
Yes, I am the petition lawyer, 7, 8, and 9. I was in interim.
Okay, okay.
And in both the cases.
All right, all right. all right.
Deeply obliged.
Item 10 to 12.
Equitable, however, in 9, respondent has not filed any return in the matter. Yes, here I think an adjournment was sought, but guess who's appearing in 10? Here?
We are appealing.
So they want some time in the morning and a prayer was made. But since you were not there and these matters seems to be tagged,
Copy. Next week.
10, it's all right.
It can.
Huh? So as prayed for by Mr. M.U. Mondal, Learned Counsel appearing in item 10, Mr.
AK Talukdar.
AK Talukdar, item 11 and 12, which is not objected by Mr. Goswami. J.K. Goswami, learned additional senior government advocate, relist when
113, man.
13, 13 dot Diva Parajit did on so and so.
Obliged.
Item number 13.
Yes, ma'am.
Lordship, my senior is unwell, so he left.
Unwell, but where is the standing council affidavits not filed till now?
Lordship, in this matter, the Assam State Education Board, they are the.
Who are they? You are there. Senior is not here. No, what about your answers? Your response?
Lordship, kindly pass over the matter for the.
I am doing something in your favor, so don't panic, ma'am. You take your seat. Yes, who's appearing in this matter for the respondent? A last opportunity was given.
That was there on what happened. Actually, matter was listed last twice already.
Yeah.
We have a viable instruction, but we are waiting for written instruction.
So you place it on the next date
Next
then?
date.
Huh?
Next
I will record that you have received
Yes.
some verbal instruction and you are trying to get it in writing.
writing.
Your name?
Zirabha.
J.
Z.
G. Heard MSG Rabha, Learned Counsel appearing for the petitioner. Also heard Mr. T.G. Sutia, Learned Steering Counsel.
Yes, madam. SF. ASSED, SF.
No, ASSED, EB, correct? ASSEB. Mr. So-and-so submits that pursuant to this court's last order, though instructions have been received, however, the same is not in written form and accordingly has sought for the written instructions in order to place the same by way of an affidavit on the next date of hearing. Prayer is allowed. Let the affidavit be filed by the next date of listing along with the relevant records and the answer scripts as earlier called for by this court by order dated 18/9/2025. Relist on such and such date. Yes, give a date. You download the order and you show it to a senior. Yes.
Supplementary list, item number
Obliged.
34 to 37.
Photo. None appears for the petitioner on call, released after 2 weeks on a date to be fixed by the registry. Next.
Item number 38.
None appears for the petitioner on call, released after 2 weeks on a date to be fixed by the registry. You're there. 38.
Rajiv, WC 6773.
Yes.
Yes, actually, in this case, also, Mr. KDB is appearing.
Huh?
I will do the case. My name is not there, Lord.
It's this is a writ petition.
Yes, yes.
Pleadings are complete.
Yes, yes. Lord.
What is the issue? Who's appearing for the other
What
side?
happened, let's say, we have been since 2011.
Who is there for the other side?
Director of higher Lord.
Where is hired? Right, next week then let them be there. Heard Mr. A. Deka, Learned Counsel appearing for the petitioner. None appears for the respondent, Higher Education Department on call. It appears that the matter is pending since 2021 and due to the non-appearance of the panel advocate for the Higher Education Department, the matter could not be proceeded in the for admission today on call. Be that as it may, relist next week at a date on such and such date. Yes. Next. Next.
Item 39.
My lord, this matter pertains to compassionate appointment. I have filed additional affidavit.
PHE. PHE. Yes, Mr. Gogor. Have you received? I think you may not have
My lord, it was in RR Gogo, he's in.
Yes, yes, that's what I thought. I could figure the commotion.
Yes.
It happens.
He's praying for a similar prayer to send it back for to reconsideration.
My lord, additional affidavit filed, my lord.
He has filed an affidavit.
Where is that? Page 62.
Page 52.
What have you said in that?
62,
addition?
my lord.
Huh?
Page 62.
Yes. Yes, what?
My lord, I am entitled as per this,
No, which para are you relying?
I am relying, my lord, kindly see this. Para 2, my lord, page 63.
Yes,
And before that, my lord, I would like to place para number 1, my lord. I would like to go through.
yes.
This, I was, my lord, selected by the DLC in a sanctioned vacant post. In a sanctioned vacant post, my lord.
Yes.
Thereafter, my lord, no communication was made. What happened, what did by the SLC. I have filed a rate petition, my lord, where it was disposed that that has to consider accordingly.
Recommended the SLC.
DLC recommended.
DLC has
Yes, ma'am.
recommended. Yes.
Thereafter, my lord, I have filed a rate petition because no community. What I did not know about.
You didn't know what happened. Yes.
Thereafter, my lord, the rate petition was disposed of with a direction to provide
Furnish the minutes of meeting of LSC means
SLC, my lord.
SLC
Yes,
before
ma'am.
the court.
Yes. Thereafter, my lord, I have filed again, my lord. I
So
have
SLC basically rejected the recommendation.
my lord. Yes, ma'am.
Yes.
Then I challenged by way of this petition the SLC.
The instant.
Yes, ma'am. This
Yes.
instant.
এইটো 5% কোটা বাহিৰ হৈ গ'ল কাৰণে
Before that, my lord, kindly see my rate petition.
Mr. Gogoi, if you are not comfortable today, then I'll have it next week.
and this is a matter which can be handled by the government itself because it has went beyond our control. It's SLC now. Had it been a DLC, we could have been.
Mr. Chute, are you are you ready today?
Oh,
Then next week.
Next week.
Next week. It seems they are not ready today.
A date,
Yes,
A date may be fixed.
I'm giving it.
Yes.
Heard Mr.
H.R. Chaudhary.
H.R. Chaudhary, learned counsel appearing for the petitioner. Also heard Mr. D. Gogoi, learned counsel appearing for which department? PhD. PhD and Mr. T. C. Chutia, learned additional senior government advocate. Released next week and on such and such date.
13-11. I said 40.
40 minute also, same issue,
Same then.
same department.
Same.
Kobiruddin, no?
Here, my lord, SLC, DLC recommended.
There also you filed your additional.
Yes, madam.
It is silo additional to ISN 40. ISN 9. Same date did you or list or lekha? ISN?
Obliged.
I said 41.
Yes, Mr. Rajkwa.
May I please about in this
Lordship, kindly pass off for a timing. My senior is appearing before DC in ideal bench, Lordship. He is coming.
Next week then, Mr. Rajkwa.
next week.
As heard Mr. V. Rajkwa, learned counsel appearing for the petitioner, also heard MS
R.R. Sekia.
R.
R.R. Sekia.
R.R. Saikya, learned counsel appearing for the respondent. Mrs. Surensu seeks a short accommodation as the learned counsel, arguing counsel on behalf of the respondent is presently appearing before the outlying bench at Aizawl through video conferencing mode. Relist on such and such date. Next week at the date did you?
13.
Ma'am, 13th is okay? Yes.
Obliged. Item 42.
Yes, Mr. Mohanta.
Wait, please, your lordship.
That an affidavit in reply was called for. Are you there?
Yes, my lord. That is on record, my lord. I confirm, my lord. My lord, petitioner before your lordship, my lord, is working as a DJM, Deputy General Manager HR.
Is
Working as a Deputy General Manager within bracket HR Human Resource, my lord. Her next promotion is, my lord, General Manager HR. So promotion, my lord, that
general manager.
General Manager. So Departmental Promotional Committee, DPC, my lord, recommended her name in way back in 24/8/2023.
Yes.
But till today, they have not been promoted on a very flimsy ground, my lord. Very flimsy ground, my lord. And in fact, my lord, my writ petition, which I have filed, my lord, they have affidavit filed, my lord, they have admitted every all paras, my lord, in my affidavit in opposition, my lord. But when this honorable court specifically, that's why he was not given permission, although the DPC has recommended her name. By this time, my lord, if I was promoted, my lord, in the year 2023, by this time, my lord, I will get the post of, my lord, Chief General Manager, my lord. So now, my lord, they have filed an affidavit. There is second affidavit they have filed, my lord. Specifically, they have asked to file, my lord, they have filed. That they have filed that the statistics there, they have stated that before this honorable court, that because of the organizational restructure, that has been not been done.
Because of
Because that is why, my lord, they have
because
not.
of what?
Because of the organizational reconstruction of the company, they have not promoted me. That
What
is done,
your fault?
my lord.
What is your fault?
Yes, that is not my fault. In fact, that organization, my lord, restructure has no bearing in my promotion, my lord. They admit it, my lord. That is also admitted, my lord. Now, my lord, your lordship, kindly see, my lord, my affidavit, last affidavit I filed before your lordship, before going to the other, my lord, which has called for today. That is, my lord, your lordship, kindly see. Page 1, it is started from, my lord, 1.
Yes, 148,
148.
connector B.
My lord. Good.
Mr. Kotoki, you received this?
Yes. Because the last occasion when case was listed before this honorable court, they said that we are going to allow his, going to discuss it in the last meeting, my lord. And that meeting proceeding was, my lord, they was placed before this honorable court, my lord. Then, my lord,
So what does that proceeding say?
proceeding, my lord, your lordship, kindly see page 147, my lord. 147, my lord. Page 147. After discussion, the board may defer the matter till the finalization or organizational structure of the company. Now, my lord, your lordship, kindly see the minutes of the meeting, my lord. Minutes of the meeting, agenda. In agenda, my lord. Page 148, my lord.
Page 148, yes.
148. So, your lordship, kindly see, my lord, they are one by one, my lord, very design manner, my lord, they have deprived me, my lord, although others are promoted, my lord. 97 meeting, no discussion. 99 meeting, no discussion. Now, my lord, your lordship, kindly see the page 150, my lord.
No, where you say no discussion, I
No,
didn't
my
get
lord,
that.
earlier, my lord, I'm not there,
Oh,
my lord.
okay,
Well, it was placed in 97 meeting, my lord.
okay,
Then 199 meeting, my lord.
okay.
Now, my lord, your lordship, kindly see page 150, my lord.
Yes,
150.
yes.
The minutes of the Departmental Promotional Committee, DPC-1, held on 24/8 enclosed here annexed. It is pertinent to mention here that the structure of the organizational structure shall not make any impact on the promotion of Srimati Chama Trivedi Lokar. Has
That-
already been become eligible for the post. On
That is the petitioner.
my lord.
You are the
So that is their minute says that is their agenda, my lord. There is no bearing, my lord. Now, my lord, your lordship, kindly see, my lord.
So what is the proposal? It is proposed for approval of or promotion of so and so to the rank. So there is a proposal.
My lord.
Approval is sought. So what is the state of the approval? I think it's already,
The first promotion committee, DPC, recommended her name. It is admitted position. And with a rider, my lord, that the matter may be placed before the board.
That is
We
also-
cannot do anything because our agenda is clear. The authority agenda is clear. Now the thing is board defer the matter.
no,
And
but now the matter has been
again,
approval
deferred,
from
my
whom?
lord.
approval is sought for whom, from whom? Approval sought for
From-
promotion.
From the board, my lord.
So who's appearing for the board?
Board is not a party here.
What is not a party here?
Board is then to
No,
have
my
to
lord,
bring
that's
board.
chairman, my lord, your lordship.
Who is the
kindly-
board? Board is not AGCL board.
Yes,
Then AGCL is a party.
party.
No, AGCL, yes,
AGCL, who is representing AGCL? Represented by what? AGCL chairman,
Chairman is same, my lord.
he's there. How can you say he's
More
not there?
particularly,
One sec, Mr. Mohanto. See, because there is no reason to sweat so
No,
much
no,
blood
no.
in this matter, because you see, everything is
My lord,
admitted.
what happened?
The only thing it looks like some technical
no,
defect
Lord.
and the matter has been kept pending. You all admit it. It should
Yes,
have
sir.
been given.
We admit.
Restructuring has no need, is absolutely not required. Everything is admitted.
Admitted.
And now only thing is that the approval from the board. So I'm posting it on Monday. You let me know within how much time frame this approval will come and finish this matter. I'm going to dispute
Well,
it on Monday.
That it is difficult to.
That is why I'm
And
saying
Milord,
you have a word with
now-
the chairman.
Yeah, Milord.
He is the board.
yes. Same,
You know, last
chairman is the
meeting-
same.
Last meeting was held on 29/6, 29/9, 26/9, last meeting. Within 120 days.
I am not on all that. It seems a lot of delay has occurred, Mr.
Okay, my lord,
Kotoki.
my lord,
Who are the members of the board? It's only the chairman or anybody
The
else
other
is there?
members are there.
Who are those?
Let me find.
You see, I'm only wanting, or I'll recall this matter to just get the information within how much time the approval can be finally given.
Any day below next.
Monday then.
Well,
Let this information come.
Chief kindly see as per the rule.
I think in that
No,
case, we
no,
can
as per
dispose
the
it
rule-
off.
As
I
per the rule,
appreciate
my
this,
lord,
Milord Vivans.
as per the rule, my lord, as per the rule, even approval of the board is also not required.
Now, you
My
see,
lord, your lordship kindly
now,
see-
without going into all that,
My lord.
it appears that, okay, which rule? Which rule?
Rule I have annexed, my lord.
Page?
Page, my lord, your lordship kindly see page rule, my lord, that is rule governed is in the.
It's admitted, Milord. There is nothing.
It is admitted, my lord.
That it is not required.
Not required.
Milord,
Show me
DPC.
the rule, show me the.
Yes, page 41, my lord, we start from page 40. Assam Electricity Gate Corporation Limited Human Resource Service Rule 2019.
Committee.
That is the rule, my lord. Your lordship kindly see page 43 rule. Rule 3. Now your lordship kindly, my lord, see page 43, my lord. Page 43.
Yes.
Rule 3, my lord. These are cadres name. These are cadres name.
Rule 3 at page 43.
Yes, my lord.
Assistant.
And yes,
deputy
now,
manager.
now I am in the serial number D. That is
Yes.
the Deputy General Manager HR.
Okay, I
Next-
understood. And general
Next is
manager.
General Manager, that next is Chief General Manager.
All right.
So eligibility criteria for the promotion, that is page 45, your lordship will find. Page 45, my lord.
Yes.
That's post
Yeah, the strength
43.
of general
The only
manager.
3 years requirement, that is already I have
Fine for
everything
promotion.
there. Now
Yeah,
your
for
lordship
3
kindly
years.
selection.
Yeah.
Appointment by promotion on the rank of General Manager, page 50.
Page.
Page 50.
Yes.
Appointment by promotion to the rank of General Manager HR.
Yes.
That is very last line. Very
Yes.
last paragraph of the page 50.
Yes.
Now, my lord. Your
One
lordship,
second, one second. The last one, an officer.
appointment by the promotion. the
Yes,
rank
yes.
General Manager.
Yes.
Now, my lord, next page, my lord.
Yes.
Next page. that-
Recommended by
yes,
the DP.
Sorry, my lord, your lordship kindly see that, my lord, I'll read that, my lord.
Go slow, Mr.
My
Mohanta.
lord, sorry,
Go
that-
slow.
sorry,
No, now I am only seeing if I can dispose it right now.
my lord.
So go slow. If I have to author it right now in the court, I will need certain facts.
Correct,
So
absolutely.
go slow. Yes.
An officer in the rank of Deputy General Manager who has completed the minimum 3 years and in continuous service shall be eligible for promotion to the rank of General Manager HR, subject to the availability of the vacancies of the GM HR and his or her suitability of the higher post of assessed and recommended by the Departmental Promotion Committee. Now, my lord, your lordship kindly see procedure for promotion.
Yes, 16.
16, my lord.
Yes.
16.2. procedure for promotion level deputy general manager is said to be
On the basis
the
of
general manager
DPC.
on the basis of the recommendation made by the departmental promotion committee.
Yes, but who will issue this order? Ultimately, who has to issue the order? DPC has recommended.
Yes, fine. DPC has recommended. That is as per.
No, DPC recommended with a rider, my lord, that it should be placed before the board.
But for what reason?
I don't know, my lord, but, that I cannot explain, my lord.
Yes, my lord.
Because there is,
DPC is the recommendation authority. They have to recommend, and as per Rule 16, promotion will be made as per recommendation.
My lord, your lordship kindly, 125, page 125, DPC recommendation, your lordship kindly see. But in the same DPC, my lord, others who were promoted, they were getting promotion, my lord, one time. I don't know, my lord.
See,
But
that's a
only that may
promotional
be-
matter. It's difficult for this court to say ki you directly now promote. That is why the difficulty.
then
Now,
can I have it on Monday, my lord?
I think that would
My-
be easier.
My lord, no problem.
Let me have the.
You have it
Yes, my lord.
because that would only expedite everything.
Everything.
My lord.
It's just a question of now just an approval seal.
No, in-
Though the
in fact,
rule
my-
doesn't contemplate, but though the rule doesn't contemplate but the problem is, you see, the promotion as per the rule is to be made on the basis of the recommendation of DPC.
DPC.
Now, while recommending, DPC says yes, but place it before the board.
Exactly. That.
Now,
But why they are
That's
trying-
the difficulty.
now going by the rules, one cannot say ki that the DPC has committed an error. DPC is the recommending. Now they did recommend, but at the same time they say, all right, you place it before the board. Maybe for some reason. Now we don't know. Anyway, heard Mr. TJ Mahanta, Learned Senior Counsel, assisted by MS PP Dattana, P Sharma, MS P Sharma, Learned Counsel for the petitioner. Also heard Mr. S. Kaktaki, Learned Standing Counsel, AGCL. The additional affidavit filed on 23/10/2025
My lord.
is placed, is available on record.
There's a 411, my lord.
Sorry, 411. The additional affidavit.
No, I'm in reply to their affidavit.
No, I'm only referring to the affidavit which was
Additional
called
filed by
today. Because earlier it was not here. So this affidavit is dated what? Affidavit in
Today,
reply.
which was called for the affidavit in reply, my lord.
Reply on.
The affidavit,
They have filed a affidavit.
No, that's all right. But the affidavit in reply which you filed is dated when?
411.
411. The affidavit in reply dated 4/11/2025 has been brought on record, is available on record. It appears that the core issue involved in the instant writ petition is the the only issue, it appears that the promotion of the petitioner as sought for in the instant writ petition is being delayed only for the inaction of the APEGCL board in not approving the same despite the recommendation of the DPC. It is brought to the notice of this court at bar at the bar that under the rules relevant, promotion to the post in question is on the basis of the recommendation of the DPC. It is undisputed that admittedly in the instant case, the DPC has already recommended the promotion of the petitioner to the subject post. However, with the rider that the same be placed before the board. That being so, the matter requires to be that being so. That being so, in the interest of Mr. S. Katakil and it's so and so seeks a short accommodation to apprise the court as as to the time frame within which the approval can be granted so as to conclude the promotion of the petitioner without further delay in the matter. Relist on such and such date. Confine it to that only. Give your appearance. Yes.
Item 43.
Yes, Mr. Sharma.
My lord, the petitioner here, my lord, 43, 44 are similar matter, my lord.
Yes.
My lord, the petitioner here are working in State Bank of India and they were being suspended due to some irregularities in sanctioning certain loans. My lord, the suspension
Irregularities of?
in ascertaining some loans, on dispersing some loans, there were some irregularities, and because of that,
What is the main prayer?
my lord, my main prayer is that it's been more than 90 days. They have not been reviewed.
Review.
Yes, and they have also started.
It's an admitted position,
Yes,
not
that's
review.
in fact, we have filed an additional affidavit also, my lord.
It's not, it's on record.
It's on record, ma'am. It's on record, my lord.
So that's an admitted position.
Yes, your lordship. So, my lord, as per Ajay Chaudhary and as per the honorable.
You are Mr.
H. Buragu.
Mr. Buraga, that's an admitted position. No review till now.
Your lordship, the State Bank of India officials, they are governed by the State Bank of Officer rules, your lordship. And as per the rules, your lordship, such review is not necessary.
Ajay Chaudhary?
Yes, your lordship. To overcome that, your lordship, there is a provision in the rules that at the end, if they are found that the suspension was unjustifiable or the allegations brought against them is not held, your lordship.
But then there's a rule.
Lordship.
All right, I'm admitting this and posting it for hearing in a short date.
My lord,
It will need some application of mine.
My lord, I have
It will not be merely going by the Ajay Chaudhary because there is a rule which takes care of that particular.
My lord, Ajay
issue.
Chaudhary is squarely applicable because.
Mr. Counsel,
My
if
lord.
there is a rule, we have to examine the rule. The matter has come for admission today. I'm admitting your case. Heard Mr. S.P. Sharma, Learned Counsel for the petitioner, also heard Mr. H. Buragohai, Learned Standing Counsel, SBI. The issue involved in the writ petition is not issuing of memorandum of charge sheet.
My lord, may I just submit here.
The memorandum is
No.
issued or not?
Yes, issued. My
Issued,
lord, in
but
fact,
not renewed.
order is not been reviewed.
Is not renewing the suspension of the petitioner in terms of the decision of the apex court in the case of Ajay Chaudhary so-and-so reported in so-and-so. Mr. H. Buragohai so-and-so submits that under the relevant rules of the
State Bank of India.
of the
officer
SBI, there is no provision of review as laid down in the decision of the apex court. However, there is what is that rule? However, under rule
68A
68A 8
1.
1 of the said rule, yes, read out.
Where the appointing authority holds that the officer has been fully exonerated or that the suspension was unjustifiable, the officer shall be granted the full.
After conclusion of the inquiry, in the event it is found that the officer, that the delinquent officer has been unfairly kept in suspension, he shall be compensated.
He shall be granted the full pay.
He shall be granted the full pay. It appears that this matter requires full-fledged hearing. Admit for hearing.
My lord.
No formal notice as parties, as respondents are represented through their respective councils. Relist at a date deduct in the month of November.
My lord, they have not
on
filed,
such and
they have
such.
not filed an affidavit in opposition. So my lord may specify.
You have not filed.
Filed, your lordship.
Huh?
We
They have
have
not
simply appeared in this matter.
They have not filed affidavit.
Oh, pleadings are complete.
No, my lord. That is what I was up to. The admission hearing, my lord.
Then that full-fledged hearing, it appears that no pleadings has been filed. However, it appears that no pleadings till now has been filed. Ruler let the returns be filed within how much? 2 weeks. 2 weeks on a date to be fixed. Then why is this matter fixed in admission
My lord,
column? That's why it got confused.
Before my
Yes, 2 weeks. Yes,
lord,
next.
My lord, before part of it records, one slight observation, my lord. My lord, what he is submitting, the CCS rules over
You will get your right
Yes,
on
my
that
lord.
day.
So,
you
my
let
lord,
it
at least
come.
on that stage, my lord, at least the proceedings, because as of
Nothing,
today,
nothing.
I am already.
Mr. Sharma,
One
let
thing
him
is-
file it, but I'm giving you a fixed date. Give him a date. Needless to be clarified that failing filing of return on the next date of listing, the matter shall be proceeded in accordance with law.
Much obliged, my lord. That would do, man. Much obliged, my lord.
Obliged.
Hmm?
My lord.
44 same.
Yes, same, man.
Or orders item number 14.
Anyone appearing?
My lord, this is a condonation petition, my lord.
Yes.
There has been delay of 494 days, my lord. And I have.
Notice has not gone till now.
Notice has gone. They have also filed objection, my lord.
Who is appearing? Who's appearing for the
This
other
was
side?
filed by
400?
Devojit Sarkar.
400?
94, my lord.
494
Yes, my lord.
for filing statutory appeal.
Yes, my lord. Review petition, my lord.
Review.
Review, and I have annexed the, I have explained the grounds that para 2 of my lord application, my lord. Page 3.
And what is the objection?
Objection according to them, my lord, this is the objection. The ground is that their objection to para 5 of their objection, that is, they have filed on 8/8/2025, my lord. They have explained at para 5 of their objection, page
All right.
7.
Okay. Third MS.
SB Chaudhary.
SB Chaudhary, learned counsel appearing for the petitioner, applicant, then appears for the respondent on call by way of this interlocutory application, comma, the applicant is seeking condonation of delay of 494 days in filing the connected accompanying review application. Stop. The grounds of reason as stated in the application reads as under paragraph 2 and 3. In response to the notice received, the respondents have filed objection wherein they have objected to the prayer for a prayer for condonation. Stop. Relevant paragraph of the affidavit in opposition reads as under quote unquote para 5, page 7. Reading of the having heard the learned counsel for the applicant and having perused the pleadings, this court finds that that there was sufficient, that the grounds urged for delay are sufficient and bona fide, and accordingly the delay is condoned, allowed review to be registered and thereafter listed.
Deeply obliged.
May I please, Lord? In item number 34 to 37, I could not appear, Lord. I was in a different court. Lord, there is an interim order operating in item number 34 and 36.
All right.
That may kindly be extended.
30, it is highlighted. 34 to
34 to 37.
all right.
Obliged.
Item 15.
In common. Item
15.
785 days.
In fact, more than that.
Huh?
In fact, more than that.
This is what statutory appeal.
Yes, true. My lord, actually the grounds of the delay is mentioned from the para number 5 to 13. My lord, initially that MSc appeal was filed before the Honorable High Court Itanagar bench. Then after the delay in that court was condoned. I have mentioned, I have annexed that delay condonation order, page 14 to 17. My lord. So my lord,
Why is the pleadings in such manner? Have you seen the pleadings?
my lord,
They don't seem very appropriate. Why are you referring to the why you should have referred to the court. Paragraph 6. Paragraph 7. You're not making submissions before the court. These are pleadings before the court.
Yes, my lord.
In pleadings, you don't say like this.
Yes, my lord.
It doesn't sound good that my lord the appellant had liver disorder, that my lord the appellant is illiterate. No, this is not very, doesn't look very appropriate in pleadings.
Sorry, my lord.
You're making, these are pleadings. Make your submissions in the pleadings.
Yeah, I
No, I'm not saying don't for you to apologize, but I'm only, next time, be more mindful. Yes.
So, my lord, the reasons for the delay in respect of filing the MSc appeal,
Hmm.
I have mentioned from the para number to 13.
Para number?
Para number 5 to 13, my lord. That's, my lord. This is the fact that, my lord, that initially we had done file an appeal before the Honorable Itanagar Bench, although
What
because
are
of
reasons
this
are
wrong
given, Ms. Majumdar?
Lordship, what we are
Any
objecting,
serious objection?
we are objecting, Lordship, to the fact that they have annexed a medical document,
Yes.
which is of 2018, Lordship. The judgment by the Itanagar bench, where in fact, the day it was dismissed, they did not appear. And then, Lordship,
That was when?
it was on 1 second. On 13/11/19, Lordship.
13,
11/19.
11, 19. So in 19, it did not appear.
Yes,
Not
I
appear,
had
but not,
appeared.
it was not dismissed because of non-appear, because jurisdiction is not there, because the
Yes.
accident, MACT tribunal is from Lakhimpur.
No jurisdiction.
No
That is the date of dismissal.
Yes, that is the ground.
13/11/2019.
And the medical certificate is of?
2018, Lordship.
And in support of that, what is it said? The appellant had liver disorder and stomach pain and and had taken treatment from 13/12. No, he says that
Yes.
13/12/17 to 12/8/18, and again from 18 to 18 until today due to head and stomach pain, so and so.
But there is no document.
That's
to
all
that.
right. It need
And
not be,
Lordship-
but it looks like he is suffering through some medical issues, and it appears that this matter was at where was this matter? And he's a resident from where?
Lakhimpur.
Lakhimpur.
Lordship, the medical
And the
document.
and the MACT appeal was claim petition was also at Lakhimpur.
Yes, my lord.
What did you say Itanagar then?
Actually, my lord, initially, it is our presence. Initially, one judgment of the North Lakhimpur court challenged before the Itanagar bench, and we had the respondent. And the matter
That
was
cannot be
admitted.
ground,
Yes,
Mr.
that
Counsel.
cannot be
That
ground.
is your ignorance.
Yes.
How can you take that plea in the?
That matter was admitted, and therefore we had filed some several MSc cases before that.
The reasons are
Just to condone the get the
Yes,
delay.
my lord,
condone,
we are
Lordship.
agree
They
to
filed
forgo
it
the-
in Arunachal just to get the delay because
you filed it in Arunachal.
Yes, you know, initially it was.
And
filed
Lordship,
Arunachal.
the medical document, he's saying liver disorder and it is respiratory infection, the medical document,
It
page
was also
29,
followed.
Annex D.
My lord, I am
The
agree.
explanation needs to be more. You
Truthful.
file an additional affidavit. I'm not dismissing it today since it's a statutory appeal. But the litigant also shouldn't suffer for all this.
Yes.
You file, but you file a better explanation because total how many 700.
785.
So you see quite a lot of delay.
Yes.
You can't you explain them properly. It is appearing your treatment is something else.
Yes.
You are saying something else. You are filing at Itanagar. Hurry, you are from Lakhimpur. The claim is of Lakhimpur. How can you file that before the Itanagar bench? The appeal from how will the appeal go? And you cannot say that no, we don't know that there is a principal bench high court.
So my
I'm
agree-
sorry,
I'm agree to forgo the interest amount of the.
No, I'm not on all that. You want or I'm dismissing it. What do you want? You want to improve it or you want me to dismiss it?
I will file additional.
As prayed for by Mr.
PR does. my lord.
So and so learned counsel for the appellant to relist after 2 weeks on a date to be fixed by the registry with liberty. No, the petitioner in the meantime, if so advised, shall file an additional affidavit in order to explain the delay of explain the delay stuff in a more elaborate. Not an elaborate. Ms. Majumdar for insurance.
Hello, like.
For hearing item number 45.
This is that MAC appeal.
What have you?
If it can't to me dekat kothai diba episode aku ahi jaba. I'll give the judgment in the court only.
I have brought one judgment as regard lordship.
GD entry?
GD entry.
Yes. But that must be a criminal proceeding.
No, lordship, say MSC lordship.
What does it say?
It is that lordship, here lordship, the claimant only submitted the GD lordship and nothing else is submitted. He has submitted, exhibited, and accordingly he brought the witness also and it was founded, it was not correct. GD was not correct.
GD was not
correct. Accordingly, claim petition is dismissed lordship. But in our case, lordship,
GD is
the
not
claimant-
exhibited.
Not exhibited, not even proved, and the claimant has submitted the accident information report that was in the police after due investigation found that the bus was offending one. Then accordingly, on the basis of the materials on record, lordship, learned member held that because they have not raised any dispute regarding the exhibiting accident
Miss
information report.
Sharma, na?
Other side, lordship.
No, you are
I'm Chaudhary.
Chaudhary, sorry.
Yes.
Miss Chaudhary, see, I have looked into your the evidence and the cross-examination.
Lord.
I mean, I'm all ready to give the judgment, but I'm only sharing this with you.
Lordship.
You have already argued. Now, whatever is there on record is there on record. Now, this court finds that in the evidence in chief, they have clearly mentioned both the vehicles,
Yes, Lord.
and that fault part is also there. In the cross, I have seen it. Both parties have given the suggestions, and both the suggestions have been denied.
Yes.
And the fact that in the cross, in so many words not said because of the truck coming doesn't make the in chief vanish. It has to be read together. Even in the cross, it is said that the truck was coming from the back, and upon the bus putting the brake, he gets injured. And in the suggestions, he denies that either was not at fault. That part is denied.
Yes,
Now, so now overall, the evidence that comes is that both the vehicles are at some fault. It looks like. Now, the accident report mentions only one. Now, nobody from the police was produced. Nobody was there. The accident report has been was exhibited through the claimant.
Yes.
Through the claimant, correct? These are the admitted position. Now, in this situation, there are two things that this court can do. This court cannot ignore the fact that the truck is also involved. That factum has come in the evidence. You see, one has to be fair also,
Lord.
right?
Yes, Lord.
Now, suppose there can be one easy situation is to 50%, 50% between the two insurer. But if I think that should be the most easiest way. Otherwise, if I send it back to the tribunal to take fresh evidence and all, it will only delay because his evidence is unshakable. That is there. Now, not if it has to be a just thing, the just and fair could only be both giving it. There was one something I remember. The other side is not there today.
Can I give
Yes, yes, please give that because I am not entering to the GD, but you give it because the GD entry apparently was also never.
Yes, yes.
Though it's a public document, and you see.
Always it is not correct. Lord.
Correct.
It
It may not be correct.
It is to be.
So, even if I ignore this for a moment, how do I ignore the evidence? Now, you see, you made a fair attempt to distinguish, but I have seen that. And I've read it. I got the court translator translate also. Everything is on record. So that is clear that as far the claimant is concerned, in his evidence and in his cross, he says both. Only accident says one. The tribunal did not. Otherwise, I will have to send it back to the tribunal to call the police and get everything examined.
That is a lordship. It will be
That
correct.
can be the other
That
approach.
can be done. My humble submission is that lordship. Supposing claimant has said lordship, they have said that involvement of two vehicles lordship. So rash and negligence driving, police has investigated lordship. I could be wrong.
No, Miss Chaudhary, I'm appreciating all your effort. But you see, in his chief, he has categorically said that the truck was coming in a rash and negligent manner from the back and hit with great force. These were the categorical evidence.
Yes, lordship. And at the same time, lordship, it was also stated.
Correct, that he pressed the brake.
The bus was in front and truck was
Correct,
behind.
and so the
They
bus
hard
pressed the
brake,
brake.
hard brake and
Correct.
everything.
So that is why I'm saying,
Involvement, I am not denying.
Correct.
Involvement, I am not denying.
but rash negligent was the
That is-
truck.
It is the lordship, insurance company, the insurer of the bus has to prove it lordship. Mere filing.
No,
GT and
you see,
is
no,
lordship.
I'm not on that. You see, Miss Chaudhary, right now these are summary proceedings. These are not cases where you need strict evidence, right? The strict rule of evidence don't come into play in such proceedings. Correct. So now, before the court, the evidence of the claimant is there. Who best is the person to say all this? Now that has been proved. The claimant.
That is correct. but-
Nobody has challenged the claimant. It's unshakably proved. Now the claimant's evidence clearly indicates whose fault. Both are at fault, not one. But this aspect appears to have been ignored only because the accident report says, and what is an accident report? Who has proved the accident report? The police was there.
Usually claimant never proves.
Correct.
Exhibit.
Correct. Correct.
On the basis of their
the-
statement, only the documentary proof is that. lordship.
Correct.
Only the documentary proof given on the basis of the statement, they have only submitted the action information.
Correct.
Nothing else.
Nothing.
On the other side, lordship, they have now, it has listed, DD
So,
has given
you
lordship.
see, and now,
DD is not in the record.
now the appellate court cannot ignore all this.
Yes, lordship.
Isn't
DD is
it?
not in the record. That is the main thing.
That is also, that is
It is
why,
not on the
you see,
record.
that is why what recourse can be taken. You
You see, at best, lordship, it can be remand.
Correct. That is what I am trying
Yes,
to say,
lordship.
Ms.
That would be
Chaudhary.
just
I
and
think
reasonable.
that would be just and
Just and
reasonable. Because
reasonable. I also think, lordship.
at this stage, it is difficult for me to ignore that
Yes,
part of the evidence.
Right, lordship.
Let them take a call then after re-examining.
Yes, time frame.
Only
will be
from
given.
that point.
Yes.
Not
only that point.
only that.
We are not disputing other
Correct.
points.
Otherwise,
that point has to
that
be-
point, and I'll fix 3 months time
Yes, yes,
and I'll
time
fix a
frame
date.
can be given,
That is what
Yes,
I'm going to
lordship.
do.
That will be just and reasonable.
My submission is that this appeal is not maintainable in the IO.
Yes.
And our High Court judgment is there, my lord, you relying upon the Supreme Court judgment. Is relying upon the Supreme Court judgment,
Yes.
but additional evidence, because this additional evidence, it was in the possession of the appellant.
I am not on that.
Yes.
I am not on GD entry. I'm not going to say a word of GD entry in my
I
judgment.
respectfully agree with your lordship, but that point is different regarding appeal is.
Mr.
Appeal is quite different.
Mr. Talukdar, right? Sorry, Mr. Bhatta, sorry. Mr. Bhatta, you see, I cannot ignore the fact that the two vehicles are involved. That has clearly come from the evidence. However, the accident report shows only one. The GD entries was not there. So I think the right approach is to send it back to the court from that point and let them take a call. I'm going to do that. Yes, please take down. Heard Mr. KK Bhatta, Learned Counsel for the appellant insurance company. Stop. Also heard Ms. M. Chaudhary, learned respondent, learned counsel appearing for respondent number. Respondent number 6, Mr. I.A. Talukdar, learned counsel appearing for respondent number 1, stroke claimant. What about the respondent owner of the vehicle, driver of the vehicle, and all that? Nobody is appearing. Respondent 2, 3, 4, and 5. None appears for the remaining respondent numbers 2, 3, 4, and 5. Despite office note dated 23/9/2022, record service completed against the aforesaid respondents, which has also been duly taken note of by this court by order dated 2/11/2022. The matter is taken up for hearing today. So, this appeal is filed under section 173 of the Motor Vehicles Act so and so against the judgment and award dated 10/3/2014 passed by the Motor Accident Claims Tribunal, Golaghat, in MAC case number 09 of 2010, whereby a sum of rupees 3,90,000 was awarded as compensation together with 6% interest from the date of filing claim petition to the respondents number 1 stroke claimant. The case of the claimant before the tribunal was that on the date of occurrence, while he was traveling as a passenger in trial court records, passenger in the bus bearing registration number ASD 25-A-5429, hereinafter referred to as the offending bus, comma, a truck bearing registration where do I get the truck's registration number? The claim petition.
AS09A 128.
Huh?
AS09A.
One second. I think I have seen it. AS20
/1286.
AS09 capital A 1286. Hereinafter referred to as the offending truck. Being driven rashly and negligently came from behind and hit the bus with great force, comma, as a result of which he and other passengers suffered multiple injuries, including fracture in the leg. Fracture in the leg, na? Stop. The tribunal, upon appreciation of materials on record, held that the accident occurred due to the rash and negligent driving of the offending bus. And since the accident report indicated only the offending bus as the offending vehicle, and only the bus as the offending vehicle, comma, exonerated the insurer of the truck and fastened the entire liability of the insurer of the bus, I, the present appellant. Stop. Mr. Bhatta so-and-so submits that the findings of the tribunal fastening entire liability on the bus insurer stroke appellant is contrary to the evidence on record. He further submits that the claimant himself in his examination in chief, translation to Google, the translation accelerator. Translation to, I got it translated. Baki that's also that thing. Oh no, it's there. It's there. Pallu. Equal, huh? In chief has clearly stated that the accident occurred when the truck hit the bus from behind, which clearly shows involvement and contributory negligence of both the vehicles. It is further, he further submits that the tribunal has erred in rejecting the version of the claimant only because the accident report mentions the bus alone, though the maker of the said report or the investigating officer was never examined to prove its contents. Stop. You had given a judgment of two vehicles.
Composite negligence.
In support of his aforesaid submissions, he relies upon a decision of the Apex Court in the case of Hania versus New India Insurance Company Limited, which is reported in 2015. SSC to me side over my to query with market. SSC at Hakibo. 2015 9 SSC 273, wherein the court held that in the case of composite negligence, in the event both the parties to the component of composite negligence are before the court and the evidence is sufficient, comma, the tribunal shall determine the extent of their negligence so that both the parties at fault are equally made liable. Stop. MS Chaudhary, per contra, MS so-and-so Chaudhary, Learned Counsel for the respondent number 6 stroke insurer of the truck, while supporting the award under appeal, submits that the accident report clearly shows the bus as the offending vehicle and that no material whatsoever was brought by the appellant to show that the truck was also at fault. She further submits that in cross-examination, the claimant denied the involvement of the truck in the accident. Stop. Anything else?
Is that silent accident information report, that was my submission, not challenged by the appellant lordship.
She further submits that that apart, the accident report, which was exhibited by the appellant as Exhibit 1, by the claimant as Exhibit 1, was also not challenged by the appellant before the tribunal. Stop. Mr. Talukdar, I.A. Talukdar, Learned Counsel, appearing for the respondent number 1 stroke claimant, similarly submits that the evidence of the claimant though as a whole, including cross-examination, makes it evident that both vehicles were responsible for the accident. However, the accident report having been prepared after investigation indicates the involvement of only one vehicle, i.e. the bus. He further submits that since the appellant in the tribunal has not challenged the accident report nor brought any material whatsoever to show the involvement of the truck as an offending vehicle, comma, the judgment of the tribunal under appeal warrants no interference from this appellate court. Stop. Now, Lekha.
Apart from my lord, there is no, my lord, issue framed before the court below in respect of this.
All right. Next.
And if no issue is framed, this court.
These are technical issues, Mr. Talukdar. Take a seat now.
Regarding composite negligence, no issue framed.
Now, apt at this stage to refer to the evidence of the claimant adduced before the tribunal, which reads as under, a relevant portion of which reads as under. It is page 23, Pava, 1 to Didiba. Paragraph 1 to Pura Didiba. That he further exhibited the accident report as exhibit 1 amongst others. During cross, it appears that during cross, it appears that the claimant has clarified as under within italics Didiba that translated by so and so, verified by so and so court, and then a English to pura Didiba. Refer koi diba. You had, Ms. Chaudhary, you had, I think, put a flag with that accident report, no? Where is that? Do you remember the page? Which number?
27. Column number 6.
Oh, yes. It appears that in the accident report submitted by the investigating officer on 25/2009, which was exhibited by the claimant as exhibit 1 before the tribunal, in serial number 6, the registration number and type in the column registration number and type of vehicle, only the offending bus has been mentioned. It further appears that there is no mention of the offending truck in the said report. However, upon perusal of the records, especially the material, especially the evidence of the claimant, it appears that the claimant in his examination in chief categorically deposed that while he was traveling in the bus, a truck coming from behind in a rash and negligent manner struck the bus with force, at great force really likes, yeah, due to which he sustained injuries. In the cross, it is seen that both the learned counsel appearing for the insurance companies of the bus and the truck respectively put suggestions to the claimant that their vehicles were not at fault, which the claimant denied. Correct? Both have seen that. Thus, the evidence of the claimant consistently indicates involvement of both the vehicles. Though the accident report mentions only the bus as the offending vehicle, the maker of the said document, namely the investigating officer, has not been examined to prove its contents. The said report therefore cannot be treated as conclusive proof of the involvement of only one vehicle. The JD entry, though not exhibited before the tribunal, are public documents and supports the version of the claimant that the truck was also involved in the occurrence. Be that as it may, the oral testimony of the claimant, which has remained unshaken in cross-examination, sufficiently establishes that both the bus and the truck were involved in the accident, and that the accident occurred due to the composite negligence of both vehicles. পিছত হেৰি কৰি দিম এতিয়া তুমি তেনেকৈ থৈ দিয়া In view of the aforesaid discussion, this court finds that the tribunal erred in fastening the entire liability upon the appellant insurer of the bus alone, ignoring the clear evidence regarding involvement of the truck as well. The scheme of the act requires just compensation to be awarded, which should be the scheme of the act mandates awarding of just and fair compensation and fastening of the liability in such a situation only to one of the defaulting party defeats the very object of fairness, equity, and justice. This court cannot be unmindful of the fact that though the accident cannot be unmindful of the fact that the GD entry, which has been enclosed in the claim petition, was never introduced at any earlier point of time before the tribunal, nor was the same, not the claimant, sorry, appellant, appellant insurer, nor was the same proved or brought as evidence by the appellant. Stop, a comma. However, the same being in public document cannot either at the same time be ignored, which clearly shows involvement of two offending vehicles, the vehicles insured by the appellant insurer as well as the respondent number 6 insurer. However, since the accident report, which is submitted after an investigation, shows only the involvement of the bus as the offending vehicle, though the same appears to have not been proved before the court, before the tribunal, by the maker of the said report, this court deems appropriate to remand the matter back to the tribunal on this limited issue alone, wherein after taking due appropriate evidence and additional evidence by all parties concerned, if necessary, only on the point of involvement of the truck and the other documentary evidence of the investigation, record a finding as regards the involvement of the other vehicle as stated by the claimant in his evidence, and thereafter reassess the that is already done, and thereafter fix the extent to which both the insurance company, in the event the truck is involved, shall be liable to be paid to the respondent number 1 claimant as per the earlier order of the tribunal. The rest of the portion remains intact, and at a date of appearance, when I'm fixing the date of appearance, send TCR date of appearance. Yes, please suggest on such and such date, and and then 3 months preferably from the date of reference, date of appearance, within 3 months to conclude.
Appearance on?
Give a date when it will be. It'll be too late.
Too late.
But it's Golaghat, so
November 26th.
it is for Mr. Talukdar for your client's benefit. I don't want it to.
26th, my lord.
26th?
Yes.
26th. It put a notice to the judicial registrar that the matter, the records has to go back before that date.
Lordship, I just make fair indulgence, Lordship. Only thing that if some evidence comes from the appearance.
I
side,
said from
all
both.
claimants,
I
they
said.
are not to call
Yes,
from
yes. I to add corridor. More additional evidence by all parties, including cross examinations.
My lord, the assessment may be reassess maybe if it be what.
See, reassessment problem comes. No.
You waive objection.
I'm not going to do that. You see, Mr. Talukdar,
Yes.
I am not on the quantum here.
Yes.
Quantum has been fixed. I am not touching that part. The only question is now whether the entire compensation awarded is going to be paid by
Yes,
the
yes, I respectfully
insurer
agree
or
with
the
you.
other.
Yeah, I
Only
respect
that.
with it. But only
This is not your appeal, Mr. Talukdar.
Yes.
Yes.
Evidence by both sides.
I've said, Mr. Chaudhary.
And what's it?
I've said it and I'm going to edit it. You will not get this order today itself. Let them type it out. I'll edit it. Mr. Rabba?
They still will be directed to return the statutory deposit.
I have সেইটো এটা লাইন লগাই দিবা সেই আগৰটো নিচিনা। ইয়াতে অকমান হেৰি হৈ আছে দেই, এইখিনি এটা ক্লিক দিয়ক না। অলৰাইট, হৈ যাব দেই, তেওঁক দি দিব।
Item 16.
তুমি যোৱাগৈ, তুমি যোৱাগৈ।
Before my learned friend starts,
Yes.
the Lordship will recall, I had concluded my arguments otherwise. Your Lordship had posed two queries. One is regarding that minor irrigation.
Two queries. One is
One was regarding the other. We had made a statement in the writ petition that other similarly placed persons in connection with another corporation, minor irrigation. There they had got the benefit. That
They have got the
benefit. They have been given the benefit. In fact, we have been able to lay our hands on that document.
Let me connect back to your facts of your case, Mr. Chaudhary. I just finished dictating, so
I understand.
it takes a little.
I agree. And this matter was pertaining to
That there was a closed down, and this is that
yes, sir.
that
The
part.
corporation was closed down.
Past services.
Pass exactly. We were the
Just sum it up that the moot issues that were involved.
The background basic facts are like this. This corporation, it was ultimately, otherwise it was doing very well. Over a period of time, because of the apathy of the government, ultimately a decision was taken to close it down. When the closure was decided, options were given to employees. Either you can opt for voluntary retirement. If not, you will be absorbed and with all benefits, service benefits. Ultimately, nothing was done. We had to come before this honorable court. The honorable single judge passed an order in our favor that we ought to have been absorbed, and absorption was directed within 6 weeks. That was not adhered to. In fact, they filed an appeal. That appeal was also dismissed. In spite of that, it was not being done. We filed a contempt. Ultimately, they absorbed. Although the closure was decided and announced way back in 2006, ultimately we got absorbed in 2011. When it was decided to absorb, they thrust upon us an undertaking, and which was not previously notified at any point of time. They made us sign a undertaking virtually all at gunpoint. We were all on the streets. Now, the undertaking was to the effect that we will not claim any benefit. And what they did was, they appointed us as fresh appointees. Naturally, the entire past service was wiped out. There were people who were on the verge of retirement, 1 year left, 2 years left. So it would hardly make any sense. So that is how the matter is before your lordship. In fact, we had, on the last occasion, we had submitted a short written argument also. That is also on record.
What is this now you want?
Now, one of the pleas that we had taken is, this is a statement that is made at, if your lordship will kindly turn to para 14. 14B at page 17, it starts.
Yes.
If your lordship will kindly turn the page to the last sentence in that.
Just 1 second. Page 14.
Page 17, para 14, capital B.
Yes.
The longish paragraph, if your lordship kindly turns the page.
Came to learn that some similarly situated. Ocha, this I remembered. I'd given you that liberty that day.
Yes, ma'am.
The minor irrigation. So you found.
So these are the.
You found.
The notifications itself.
Yes. What does it say?
If your lordship takes up the notification dated 13th May.
Yes.
Serial number 3.
Yes.
Would substantiate the point.
They are entitled to pensionary benefit
as admissible under the Assam Services Pension Rules
on their absorption appointment in irrigation department. And they were absorbed again from where?
From minor irrigation.
From minor irrigation.
This was a corporation by the name of Assam State Minor Irrigation Development Corporation.
Where do you get that in this?
in this particular.
ASMIDC? No.
Yes, man.
Huh?
ASMIDC.
ASMIDC Limited, right?
Yes.
What is the full form?
Assam State.
I got it. Assam State Minor Irrigation Department Corporation.
Development Corporation.
Development Corporation. Okay.
So this was one issue, my lord. And the other issue, your lordship wanted to have a look at the order passed in the contempt. Unfortunately, my lord, it's a very, very old contempt. Number. My lord, perhaps the records will have to be called for, my lord.
Can you, Mr. Chauhan, give the number? Give the number to the court master. It will break out submission.
Contempt case number 195 of 2008.
I said contempt case number.
2008, 195 of 2008. And ultimately, once they complied, when they complied with it, we withdrew it on. The date of disposal is 29/6/2011. So these are the two queries that you lordship.
You'll give a reply at 2 or another date?
Lordship, at 2, I have a fixed matter, Lordship. If Lordship takes up this matter around 3, Lordship, it will be.
Around 3, it may be difficult. I'll get involved with other matters. Then I can give you next Tuesday. Until then, we can get the contempt file also. Right? So, heard Mr. I. Chaudhary, senior counsel, assisted by Mr. R. Chauhan, learned counsel for the petitioner. Also heard Mr. P. Nayak, learned counsel appearing for the advocate, the additional advocate general liquidator for the state respondents. We heard in part, let the records of Mr. Chauhan give properly that name. The records of so and so be called for on the next through the registry. Relist on Tuesday. Tuesday, Mr. Nayak? Relist on Tuesday as part of it. A written argument was given. You have received.
They have also
copy,
given.
No, you have given. About one,
It was submitted on behalf of the agriculture department, not.
About side person, you ask again, right? Not in the Khanajan Lagila. তেওঁলোকৰ টো যদি আছে আৰু লিখি দিলে হ'ব এটো কি না petitioner বুলি ভাবিছিলো তো এবাৰ চাই লব just have a look in case your thing is not there then give it huh?
Lordship, kindly fix this matter on Tuesday. Due to some personal difficulties, my senior is not able to.
Who's your
present.
senior?
D. Gogoi.
Your name?
S. Borpujari.
MSS Barpujari, Learned Counsel for the petitioner, seeks accommodation only for the day in view of the fact that the arguing counsel, Mr.
D. Gogoi.
D. Gogoi, has personal difficulty, which is not objected by MS P. Rabha,
On behalf of the
Learned
state.
Counsel appearing on behalf of Ms. A. Gayan, Learned Counsels appearing for respondent numbers 1 to 5. Relist Tuesday, relist on such and such date. Miss Majumdar was here. Where is she?
Yes, my lord. First appeal, my lord, filed by the claimant for enhancement, and second appeal, the item 24, filed by MS Majumdar, my lord.
She's not here.
Yes, that's why, my lord.
So should we have it on another date? Because I saw her in the first hub. She was there. She's generally always there. So we can have it next week or what?
Yes, my lord, next week, my lord, with the agency is there.
So tell me a date. You inform her.
My lord.
Her junior is there.
My lord.
No, okay.
From 15 to 30, I am not here.
Very well. You suggest a date after that. Mr. Islam, na? Heard Mr. R. Islam, Learned Counsel appearing for the appellant in item 23. Also heard Mr.
H. Moria.
H. Moria, Learned Counsel appearing for the
Respondent number 2.
respondent number 2. Ms. Majumdar's junior is also not there.
No, my lord, I have not found, my lord.
On prayer of MS R.D. Majumdar, learned counsel appearing for the, should I say that or otherwise she's not here right
My
now?
lord,
No, non-appearance for the
That matter.
appellant in Mac Appeal 357 of 2019, relist again on such and such.
my lord, 2nd of December. Much appreciated.
দুটা একেলগে আছে, হা?
Item 25.
May I please, your lordship?
Yes.
Your lordship may kindly adjourn the matter for the day as due to the sudden demise of the family members of the conducting council, she is unable to appear before the.
There is a bereavement in the family.
Yes, your lord.
Your name?
F. Shaheen.
Any objection? There is a bereavement in the family of the heard MS?
F. Shaheen.
F. Sain, learned counsel appearing for the appellant on learned counsel appearing on behalf of MS?
A. Begum.
A. Begum, learned counsel for the appellant. Also heard Mr. A. Islam. Saha, sorry. Learned counsel appearing for the respondent insurance.
Respondent.
Huh?
Sole respondent.
Sole respondent, huh? MS so-and-so seeks accommodation on the ground that MS so-and-so, there is a bereavement in the family of MS so-and-so, learned counsel for appellant.
Lordship, death may
Released on such and such date. Yes,
after 16, Lordship, I will not be available for a few days in coming week.
they will give you. When do you want?
Much of
May.
19 is okay? 19 November.
much of.
Item 26.
To R.D. Majumdar. 9. None appears, relist after. Take it on to detail. Your Mr.
KK Doctor.
KK Datta. Ms. Majumdar, this is your matter. That has, we have passed the order. Now, I'll record your presence though. In that DD R.D. Majumdar presence. Now this is, it will be matlas? 26. 26. What is this, Ms. Majumdar?
Lordship, we have filed the three.
Before we go to this, I was there's an academic question.
Yes, sir.
I think you would be one of the best person to
I'll try.
be for answering the query that is in the mind of this court. In these 173 appeals, now in a situation where the appellate court finds that the evidence are inadequate and insufficient, what is to be done? Where is that power given?
Power
is not there.
Statutorily, it is
It's not there.
No.
But it is done to remand.
Yes.
Correct.
to remand.
Now, generally, you see, because why I'm asking, because MV Act otherwise are beneficial and it is for the claimant. Now, here the claimant is armed with a award in his favor of compensation. At the same time, it appears for XYZ factors, that the compensation either fastened upon one of the insurance company. Yes.
That Lordship, what I would
Yes.
say, Lordship, since Lordship is looking at the claimants.
Yes.
What Lordship can direct, if I'm just
Yes,
submitting
yes.
Lordship, that whatever insurance company, suppose it is my insurance company, it is directed that, so Lordship can direct that this insurance company will pay to the claimant, and Lordship then can remand the matter, no issue, and it can be decided by.
And later on
later on.
adjusted.
Emblem Devi judgment is here because.
Which one?
Emblem I can give.
Please give that.
Yes. And can I want Supreme Court judgment? Emblem is our High Court. Can I, Lordship, this is contributory or composite negligence? The claimant is not.
Correct, at fault.
No,
So
not at fault.
contributory will
So
not
the
come.
claimant can file against anyone.
Correct.
So if the insurance company have some issues, then they can ask for
Correct.
a remand.
This
and-
is what I was thinking
Yes.
after I have dictated when I went inside. This is what troubling me.
Yes. Because
So,
claimant is suffering for no fault
correct,
of
correct,
his.
correct,
He has reduced
correct.
efforts, he has.
Admittedly, that part of the judgment is intact. Now
I
the
didn't
question,
listen to the whole judgment, but I could.
correct. Now
understand what
what is concerning is the extent.
But now since Lordship gave a time, Lordship
3 months.
3 months, so okay, they will be getting their, then again, if someone comes to appeal, again to avoid that, what usually is done is let the claimant get it and the insurance
You give
company.
me those reference, please.
Tomorrow I can
Yes,
send,
yes,
Lordship,
yes.
my junior will get.
Yes, borrow by Kodibarupa. Please give it to my court master tomorrow. I think my regular court master will be here today. He just
No,
fall
anyone will give.
fall sick. Probably with the air conditions working, he may have just fall sick and he's gone. He had to rush back.
So the claimant should not suffer, that is the essence.
Correct. That's the essence, right? So that's why. All right. Thank you. Yes. What is your case?
Yeah, Lordship, I do not have a very great case.
You being humble. Yes. Let's find out.
Thing is, our grounds are that, Lordship. Claim petition was filed under section 166 MB Act, but no FIR, no charge sheet was there. Our High Court judgment, Hananya Rabha and all judgments are there, Lordship, that FIR and charge sheet has to be there. Then, Lordship, the GD entry that they mentioned in the claim-
FIR and charge sheet not there.
not there, but. And Lordship, the GD entry that they mentioned in their claim petition, they mentioned only a GD entry. This did not mention about any vehicle or rash and negligent driving, though there is another GD entry, Lordship.
Yes.
Then, Lordship, about the treatment, 35%
You are the insurance company.
insurance company. Disability was taken and the doctor who proved the exhibit 7 had not treated the claimant. So Rajkumar Ajay Kumar judgment from Apex Court is there, Lordship, wherein it has to be like the doctor who treated. Evidence of doctor is very important when it is the injury case. This is injury case. That is one judgment, Lordship. Can in other cases also, Lordship, it can be used for injury cases, Lordship. So what we are again agitating, Lordship, is that cross-examination that was done of the doctor was not taken into consideration. And Lordship,
Esther Chalia, you are appearing in this matter?
Lordship, I am appearing for respondent number 3 in this matter. For the
Unusual to see you in a MacPeel.
Lordship, yes, Lord.
Good, good. You must.
Yes, Lord.
for the owner, I suppose.
Yes.
And then, Lordship, we have also agitated the income taken as 6,500.
Income is?
6,500.
Yes.
And Lordship, we are also the disability part, Rajkumar Ajay Kumar. Then Lordship, disability itself, one law point is that disability itself will not amount to loss of earning, Lordship. A disability has to reduce the earning capacity of the person. So if someone is working in an office, if he
Just one second. Apni Matila handle.
even
Yes.
if that person is disabled, but he might not have a loss of earning capacity, a loss of earning because he will be getting his salary. Compared to that, if suppose a driver or someone, a laborer, if he is disabled, then naturally his earning capacity will be affected by this.
Here the claimant is?
I am for the claimant. I am for the claimant.
Yeah, claimant is what? You were working as what?
They did not.
Businessman.
Businessman.
Business, small businessman, petty business, and 6,500 was taken.
Let's go to the judgment then.
Yes, Lordship. Then judgment, Lordship, starts at page 10, Annex 1, and the main judgment starts from 11. This MSc case has been filed by claimant Sri Dandiram Kolita through his wife Anjali Kolita under section 166 of the MV Act, claiming compensation from OP number 2 and 3, owner and driver of the pending bus bearing registration number so and so, and OP1 insurer thereof, United India Insurance Company Limited, to the tune of rupees 20 lakhs for causing him injury in a road traffic accident that took place at Baihata Chariali Chowk at about 6:40 p.m. on 7/10/2015, involving the aforementioned offending vehicle. The fact of the case in brief is that on 7/10/2015 at about 6:40 p.m., while the claimant was waiting in the roadside for a bus at Baihata Chowk under Baihata PS, then a bus bearing number so and so, which was coming from Rongia side towards Guwahati and which was driven by the driver in a very high speed and in a rash and negligent manner, knocked down the claimant from backside, as a result of which he sustained grievous injuries on different parts of his body. According to the claimant, the accident took place due to rash and negligent driving by the driver of the vehicle number so and so. The opposite parties number 2 and 3, owner and driver of the offending vehicle, did not contest the case and the case proceeded ex parte against them. However, the OP number 1, insurer of the offending vehicle, contested the case by filing written statement. The opposite party number 1, United India Insurance Company Limited, in its written statement, denied most of the averments made by the claimant in the claim petition and wanted strict proof thereof. The opposite party number 2 not only disputed the factual aspect of the case but also declined to accept the liability if there was any violation of the terms and condition of the insurance policy, as if the rider did not have valid and effective driving license. On the basis of the pleadings, the following issues are framed under: whether the claimant injured Dandiram Kolita sustained injury in the alleged road accident dated so and so involving the vehicle number so and so bus, and whether the said accident took place due to rash and negligent driving of the driver of the offending vehicle. Whether the claimant is entitled to receive any compensation, and if yes, to what extent and by whom amongst the opposite parties the said compensation amount is payable. During inquiry, the claimant examined himself as PW1 and also examined 2 other witnesses, including 1 doctor, and produced a number of documents. The contesting opposite party did not adduce any evidence in support of its case. I have carefully perused the entire materials brought on record, heard the submission made by the learned counsel appearing for the parties, also the written arguments submitted by the claimant as well as insurance company, and decided the issue as under.
Majum, just 1 second. Yes, please.
Decision and reason thereof. Issue number 1. In this case, the evidence of the claimant is that on 7/10/2015 at about 6:40 p.m. while he was waiting in the roadside for a bus at Baihata Chowk under Baihata PS, then suddenly a vehicle bearing number so and so, which was coming from Rongia side towards Guwahati side and which was driven by driver in a very high speed and in a rash and negligent manner, knocked the claimant from backside, as a result of which he sustained grievous injuries on differing parts of his body. He has categorically stated that the accident took place due to rash and negligent driving of the driver of the vehicle number so and so. After the accident, he was immediately taken to GMCH and was admitted there on the day of accident, that is on 7/10/2015, and was discharged on 12/10/2015. He was again admitted at GMCH on 25/11/2015 and was discharged on 11/12/2015. Thereafter, he was admitted at Popular Nursing Home, Patna on 11/1/2016 and was discharged on 1/2/2016. Due to the accident, he sustained compound fracture of the left leg. In support of the oral evidence, he produced the form number 54 as Exhibit 1. Extract copy of Baihata PS GED number 253, GMC prescription as Exhibit 3, discharge certificate of GMCH as Exhibit 4 and Exhibit 5, discharge of Popular Nursing Home as Exhibit 6, disability certificate as Exhibit 7, pathological report as Exhibit 8 to 33, prescriptions and advice slips and vouchers, bills as Exhibit 34 to 259, tickets as Exhibit 260 to Exhibit 266, photograph of the claimant as Exhibit 267, X-ray plates as Exhibit 268, and Annexure A as medical reports. Sri Harish Chandra Kumar, ASI, Baihata Sareli PS, is examined as PW3. He has stated that as per Exhibit 2, GD entry number 253 and 255 dated 7/10/15. The date of accident is 7/10/2015.
So there was no FIR.
No.
Hmm?
No FIR. Only the GD entry. So
That
GD
is an information.
yes, that is an information. But if was injured, Lordship, but Lordship, I have one impediment. Somehow my packet of the other packet of this about GD entry and Rajkumar Ajay Kumar about disability. That I have no night. That I'm missing.
No problem. Then
we
I can
can-
have it next week.
Yes, Monday also, no issue. Monday or Tuesday.
I'll have it on Monday then. Yes, you want to say something?
No, Mondays I'm.
When will it be convenient for you?
Tuesday.
All right, Tuesday. Okay, Tuesday already কেইটামান matter fix হৈছে নেকি? I ল'ব নহ'লে Thursday কৰিব নহ'লে Tuesday. এবাৰ এক মাতি দিব হা? Just 1 second.
I'm so thankful, Lordship.
No, that's all right. So, you were mentioning another decision of the Apex Court where there has to be a FIR and charge sheet, you said. What was that you said
No,
initially?
Can I just about contributed in English?
No. About your
this-
case.
Oh, there has to be no our High Court. Lordship,
What?
That is
So that you don't have. You don't have.
Artichick and
So according to
then-
that, there has to be a FIR and a charge sheet.
Yes. And if the police does not pay, then in that case, the government was directed to pay the compensation. Why they did not file a FIR is a must. And when there is grievous injury, death and grievous injuries. So
What
that-
does it mean, Lordship? FIR means first information report. It means when one person informed through GD. That's simple.
So
What you want it to
anyway, she
specify
wants to
exactly.
rely on some decision.
okay, Lordship.
Let's have a look at it.
And as per Rajkumar Lordship, it is stated that tribunal has to call for a medical board. It is a duty of the tribunal, not to reduce the doctor by the claimants.
You are for whom, Mr. Chalia?
I'm the owner and the driver. I am the owner of the vehicle and the driver.
You don't have to pay.
Yes, Lordship, that we will.
He
face the
is no way.
Yes.
No
We
way.
will face the consequences of the FIR and the further investigation.
Criminal investigation going on.
No.
No, you won't. It is for the judgment. It is the police
Yes.
who are responsible.
No, you will not file an FIR.
No, we will not. We will be part of the.
If there is a investigation,
Yes, Lordship.
then of course you will face the trial. But looks like there was no investigation.
Yes.
But anyway, DD entry was there.
Yes.
So maybe an accident report was prepared.
Yes, Lordship. On that basis, accident.
And as far as the motor vehicles are concerned, here we are not looking for a strict
Yes.
proof of
That
the
is
criminal liability.
preponderance of.
Correct. All that needs to be seen is that two vehicles are involved.
Yes.
I'm sorry, a vehicle has
Vehicle is
vehicle is involved in the accident
166.
in a public space. Correct. I think that is the paramount requirement, isn't it, Ms. Majumdar?
Yes.
Vehicle and public.
Exactly.
Heard. Yes. Heard MS R.D. Majumdar, Learned Counsel appearing for the appellant. Also heard Mr. K.K. Datta, Learned Counsel appearing for the respondent number 1, 2 claimant, and Mr. A. Chalia, Learned Counsel appearing for respondent number 3, 4 stroke owner driver.
Yes.
Owner driver. As per list on
No, 11.
10, so and so. to enable MS so and so to produce the judgments in support of the argument. Yes.
Maybe Pathan or
No.
Okay.
Let's see.
পাঠার করিলে মুশকিল হয়।
You never know what will happen.
yes, Panch.
Item 27.
আমাদের নাকি? আমার কোন কোন?
Yes.
Please, Your Lordship. It's a small matter. Issue is simple in this case.
Where is the other side?
Name is shown. in the first
Yes, 3 names.
Names are
Mr.
there.
Acharya, Mr. Datta, Mr. PM Datta.
This issue is very simple in this case. My claim petition dismissed on the ground that I have not annexed the 54 form.
You are the claimant.
I am the claimant. My husband is died 2012. And
You did not annex what?
54 form.
The form, requisite
It
form.
is not required, Your Lordship.
The technical issue.
Technical issue, because we have annexed the.
Let them be there with the appeal. As no, heard Mr.
Yes, sir.
S. Islam, S. Islam, no? S. Islam, Learned Counsel appearing for the appellant. None appears for the respondents on call. Next week, Digdar Batar week or Pisa that they did
Fix a date, yeah.
on such and such date after next week.
18. Oblige.
Item 28.
Yes, Mr. Munir.
My lord. Well, this is against the selection process, my lord. We have challenged the selection process. For the selection was for the post of peon cum chowkidar.
Yes. Mr. Shutya?
Yes, we have filed affidavit here, my lord.
Yes, I believe so. And reply is also been given.
Reply, yes.
Yes. So are you all ready? Yes.
Petitioner, my lord, initially he was in the Department of Information there. He was working on honorary basis, my lord.
On a honorary basis.
Honorary
Yes.
basis. Thereafter, my lord, a selection, an advertisement was made. He participated and he was not successful. He made a we approached this court, my lord, and this court, my lord, they passed an order saying that he may be considered when as and when the vacancy arises in the next course only. Thereafter, on 2000.
Okay. That was one of the judicial order in your favor.
Yes.
That to consider your case whenever a vacancy arises.
Mine.
Okay, then
Thereafter, my lord, in 2018, an advertisement was issued. He participated, my lord, but in the advertisement, there was nothing, no remark was made that
no
statement was there with regard to that the persons with honorary basis would be considered, my lord. He approached this court, my lord. Then this court said, my lord, that one post shall not be filled up without the leave of the court.
so twice you had already come.
Yes. No, one post in the peon cum chowkidar will not be filled up without the leave of the court. Thereafter, they issued the selected candidates, my lord, filling up all the posts. We approached this court, my lord, and one other leg of argument was, my lord, that there were 50 questions, my lord, and the petitioner made RTI queries, my lord. There it was replied that he received 52. But in their affidavit, they have clarified that these 50 questions were carrying 2 marks.
Were carrying
2 marks. But in the question papers, my lord, it said 1 mark, so we took it as one of the submissions, my lord, one of the argument. But in their affidavit, they have clarified that all the questions, 50 questions, they were carrying 2 marks, but because of some typographical error, it was not reflected in the question marks. So we are not placing it that argument, my lord. But the first argument is that without the leave of the court, they have gone forward and released the result, my lord. They have given the result and filling up all the 10 posts, my lord. They did not keep any post
vacant.
And other leg of argument is they have filed their reply, my lord, in their reply, they have given the marks obtained by the candidates, my lord, for in 3 of the centers, my lord, and all
Few of the centers.
centers. And all the marks, my lord, everybody got the similar mark, 46 for that.
That these are very limited jurisdiction. How to go into all these aspects? In 226. This is a selection.
Selection, my lord. We've challenged the selection process, my lord. The process itself, if I may take their affidavit. in-
No, we will go one by one
Right.
since it's for hearing. You first give me the facts because you have just briefly stated your leg of arguments. So I appreciate it. So I know this is the kind of arguments that is going to come.
Right.
But what is the facts of the case and what happened in the earlier 2 proceedings where those orders, you place all that first?
Yes.
And then we'll go to the replies.
Page 38, 37, my lord, that the initial order, my lord. 37 it starts, my lord. 38 is the 39 is the operating part.
38 it starts. This is the first writ.
First writ petition. That is in 2009, man.
Yes.
I'm placing the
Yeah,
39,
please.
page 39 I'm placing before lordship. In view of the above, the writ petition is disposed of provide
Just 1 second. Let's a short order. Start from 38. The facts will also
by
become
means,
clear
by means,
by means of this.
yes. By means of the writ petition, the petitioner has prayed for a direction to the respondents to absorb him in any grade 4 post in establishment of Directorate of Information and Public Relations, Government of Assam. It appears that the father of the petitioner has retired from the service on 2004 on attaining the age of superannuation. According to the petitioner, he has been discharging his service under the respondent since 1999 on honorary basis. In this connection, he has annexed a certificate issued by the District Information and Public Relation Officer Mongoldoy to the petitioner. Such a certificate speaks of the honorary service of the petitioner. By Annexure 4, letter dated 18/2/2004, issued by the Additional Deputy Commissioner Darang, has requested the Director of Information and Public Relationship Assam to accommodate the petitioner against the grade 4 post. In response to the advertisement inviting applications to the post of grade 4, the petitioner had offered his candidature, in acceptance of which he was invited for the selection held on 15/12/2008 and 16/12/2008. It appears that he was not selected. According to the Learned Counsel for the petitioner, having regard to the long length of service, the petitioner should have been selected for appointment, giving weightage to his past service. On the other hand, Mr. Chakraborty, Learned State Council, referring to the stand of the respondents in the counter affidavit, submits that even if the petitioner has rendered any honorary service, same by itself cannot clothe the petitioner with any right to absorb him. He dehorsed the requirement rules. He has also submitted that since the petitioner could not qualify in the selection, he could not be appointed. None of the documents annexed to the writ petition would go to show that the petitioner was engaged even temporarily. It is his assertion that he has been discharging his duties on honorary basis. Needless to say that in public employment, appointment will have to be on the basis of the recruitment rules, giving opportunity to all eligible candidates. Merely because he rendered honorary service, he cannot claim automatic regularization or absorption.
This is the finding of the court, none of the documents, isn't it?
Yes.
Yes. Yes, read.
Yes, in view of the above, the petition is disposed of providing that as and when vacancy may occur in the establishment of respondents, the case of the petitioner shall be considered for the appointing along with other eligible candidates, taking note that he has rendered honorary service under the respondents for which he might be entitled some weightage in the experience column.
Experience column.
So that is only for that part.
Yes.
So what has not been done? In the advertisement, this need not be figuring. This is only for consideration.
Expense column is not there.
Because you see, advertisement is for everyone.
Yes.
Now there, if something like
That is
this
why
comes,
the subsequent petition was withdrawn later on.
correct, because in that advertisement, how they can make this honorary thing for the other, then so many might come, who knows. So anyway, ultimately, therefore, what Mr. Chutia, perhaps this part was taken in some weightage was given.
No, no, Malad, their experience is not given in the advertisement. His grievance is that experience should be there. How he can detect the authority to?
No, but did he participate?
He participate, he failed because I'm saying, Malad, the fact I know well of this case. 2008, Malad, is I think the fourth round of litigation. He every time advertisement he appeared, he failed. Then he filed a writ petition, dismiss. Again he filed, dismiss. Again filed, dismiss. And last, this is one. This one, only point one is, Malad, he says, in the RTI, he has been informed as you are getting 52 marks. Regarding this, in affidavit, we have clarified that said guidelines is, the guidelines also kindly see.
That were pressing, 52, 55, I'm not pressing.
No, that is the, where they are taking the plea. Lordship kindly see page 50.
I'll see later, but you just tell me.
Yes. Clarifying all these things.
Yes, later you clarify, but just tell me in short, yes. Then what happened?
Whatever much. 4 persons are same name, and a petitioner sometimes written Malad Atpuria instead of Kolita. So in mistakenly from the authority given the another marks who got 52, but those are selected, they are above 96, 94, 95. Even though he does not come to consideration.
So, and there are, I don't think any malafide or arbitrariness has been pleaded as such.
Yes, yes.
His only case perhaps is that because the court, because there is an order from this court whereby honorary
honorary is nothing
has
but
to be-
affidavit has been filed by the District Information Commissioner. There is no record that he was engaged in honorary. In this case,
No, but then this in this at page 39, you
yes,
see,
39 also says but there is honorary.
39, it is quite clear, Mr. Chutia. In view of the above, the writ petition is disposed of, providing that as and when vacancy may occur in the establishment of the respondents, the case of the petitioner shall be considered for appointment along with other eligible candidates, taking note that he has rendered honorary service under the respondents for which he might be entitled some weightage in the experience column. So basically, the factum of his rendering honorary service is accepted in this order.
Not accepted.
Yes,
No,
taking note.
No, that is true. Another
It doesn't say taking note that if he has, the word if is not there. If is not there.
Yes, yes.
It is not there.
If is there, Malad.
Where is the if?
Logically page 30,
No,
38.
38 you can forget now. 39 is the operating portion of the order.
He says giving wastage means there should be a expense column.
No, that I understood. Now, I'm not on what he is saying right now, but otherwise, if we have to understand the first judicial order.
Yes.
So the first judicial order, no doubt, have said that an honorary is not entitled and all that, no doubt. At the operating portion, what has the court directed? Read that.
Then he has rendered honorary service under the
Taking note that.
respondents for which he might be entitled.
So there are two things here.
Yes.
First thing is that he has rendered honorary service.
Honorary
This
service.
factum is admitted by the judicial order, which you have never challenged. So this attains finality.
Yes.
Now the next is that for which he might be entitled some weightage in the experience. Now this is your discretion. Correct. This is your discretion that because he gave you this service, so in the experience column, you may give him some leverage,
There is
some weightage.
in the advertisement, he expense column. That's why how much will be given. That is the question. Now he says the advertisement is this advertisement.
Now, when this writ petition was initially filed, there was an advertisement.
Yes.
Their experience column was there.
Nothing.
Huh?
No,
Nothing, Balam.
page 43, man.
That first advertisement.
No, not the first.
No,
Subsequent to this.
See, when you file this writ petition, initial writ petition, right? Where this order was passed, 21/9/2012. This was against which advertisement? Where is that?
That is not annexed. man.
I want that.
Page 44.
Is it there?
Yes.
I want to see that.
Page 44 and type copy
44 is the subsequent order, which we have put to challenge in this.
No, no, I want,
I gathered, my lord, but that is not. in-
but then you bring it.
Right.
I want that advertisement.
Right.
What was there? Probably there the experience was there. Now,
Nothing.
if later on they removed it, then you have a case, you see. Try and get it. Because if suppose there was no experience, then of course you see, now you cannot say that no, because experience is there, now you put experience. Because what they're going to put in that advertisement is their domain. Are you understanding, Mr. Munir? Correct. So therefore it becomes, it's very important to know what were the terms of the
Condition of the advertisement.
of
Yes,
that
yes, yes, yes,
advertisement. Let us have that first.
Whether selection is made in terms of the advertisement or not.
Correct.
Yes.
Let's have a look at it.
Yes, sir.
You have that advertisement date is available. Do you have the date, the 2018 advertisement?
18 advertisement, yes, my lord. In our affidavit, lordship can see. There is 21 December 2018.
21
December 2018.
Mr. Chutia, you also, if you get the advertisement,
I have got to connect it.
you have it?
Yes, our
Advertisement.
Yeah, yes.
Where is it?
In our affidavit.
This is the subsequent advertisement.
He is saying this is the subsequent advertisement.
2018.
Lordship want to know the earlier.
Earlier one.
Yes.
Before this order passed.
Correct.
Justice B.K. Sawant.
Correct.
Yes, yes. That is the advertisement, I think.
That I need.
Yeah. I'll have to obtain from the record.
You please have it and Mr.
Yes, yes, I have.
I'll try.
You have it?
And I don't have one.
No, he says. You get it, you put it on record. Let
Yes,
me know
yes,
to
yes,
see.
yes, yes.
All right. Heard Mr. PK, na? PK Munir, learned counsel appearing for the petitioner. Also heard Mr. T.C. Chutia, learned additional senior government advocate for the state respondents. It appears that let the advertisement pursuant to which this court in the UPC 298 or 398? 298? 298 of 2009 by judgment and order dated 21/9/2012. 298. Directed that as and when vacancy may occur in the establishment of the respondents, the case of the petitioner shall be considered for appointment along with other eligible candidates, taking note that he has rendered honorary service under the respondents for which he might be entitled some weightage in the experience column. Stop. Mr. Munir submits that since in the subsequent advertisement, the experience column has not been fixed, he has suffered prejudice, ultimately for which the present writ petition has to be filed. Correct?
The earlier advertisement is dated, my lord, 11/11/2008. It is from their affidavit. 11/11/2008.
Advertisement dated 11/11/2008. 2008. Since the aforesaid advertisement dated so and so is essential in order to effectively decide the list in hand, let a copy of these advertisement dated so and so be placed before this court by the learned counsels appearing for the parties. So you give it relist on such and such date.
Yes,
Until 29.
May I please your lordship?
Yes.
Lordship had otherwise heard the matter at length, and on 26/8/2025, Lordship, my part was concluded, directing the respondents to
Produce relevant record. Where are the
record.
respondents?
If your lordship will allow, I may recapitulate the facts in.
But where is, yes, Mr. Cholia? Why are you behind?
Here, I'm appearing for the finance department here, Lordship.
Who is going to give the
The
records?
Lordship, he was the employee of the DC.
Ah,
Government.
Oh.
The government, yes.
why so much commotion with the panel
No, Lordship,
advocates?
stand is in the pleadings itself.
Lordship, my senior friend CC Sutia was.
Yes, Mr. Fukan?
Kindly see order dated 5/8/25 of the 5th of August 25. 5/8/25, the orders.
5?
5th of August.
Yes.
City party, I think, is the government,
Yes, that's what he's saying.
They were
Where-
asked to, were directed by the court to bring.
To records, where are the records?
He was there.
This is Chutia, yes.
He was
He was just there. Records were called by 5/8/25, then subsequently on 26/8/25.
Not reached.
Is this part heard?
At part heard only for further hearing. My part was concluded on 5/8/25. My
I
part,
don't think this is part heard.
Lordship will see order dated 5/8/25.
Oh, yes. Upon completion of the argument of the learned counsel, the petitioner state respondent directed to produce. Mr. Goswami,
Lordship, I may be given.
you take
I will-
instruction,
yes.
and I'm fixing it next week.
Lordship.
It's a part heard matter, it appears. Next week?
Next Thursday, Lordship, if not informed.
Heard Mr. J.G. Sharma,
Yes, sir.
learned counsel appearing on behalf of the petitioner, A. Chalia, standing counsel finance for R5, Fukan for R1, and J.K. Goswami, additional advocate,
3, 4, and 6.
additional senior government advocate for the state respondent 3,
4 and
4,
6.
and 6. As the matter was posted today for production of records, Mr. Upon Mr. So-and-so seeking a short time for doing the same, the matter is posted on such and such date for further hearing.
18.
18, next.
Alright.
Item 30.
Yes, Mr. Pathak, you've been waiting for a long time.
My lord, since 1997, my lord.
Huh?
The case pertains to
But
1997.
its registration indicates 23.
23, my lord.
Yes.
What happened that is this particular person, my lord, while serving in the Assam Rifles, on 2nd July 1997, he goes missing. Now, he had a family in somewhere in Uttarakhand. His wife was uneducated. They did not have any information at all as to what had happened to the husband who was posted here in the Northeast. So after a long time, my lord, the Assam Rifles told her that you should file a FIR and get the matter processed. She filed a case also for declaration under section 108 of the.
What is the prayer here?
The prayer, my lord, ultimately pension was granted. Pension was granted, but it was granted from a date of 1st of October 2005. My claim is that the pension would be payable from the date on which he goes missing. That is on 2nd of July 1997. Now the
You
law
are
is
backed by the any law?
The law,
in your
my lord,
state?
says, the law says that as far as CC's pension is concerned, my lord, initially the rules were silent and it was backed by a circular saying that in cases of missing persons, this 7 years wait for a family to get the pension is too harsh. So therefore, upon intimation to the police station that the person has gone missing and upon furnishing of an indemnity bond, a pension is to be released. Now, this particular lady, of course, because of her circumstances, she could not lodge an FIR. She lodged an FIR sometime in 2004, and in 2005, a report comes that he is missing. And thereafter, she files a case also for this declaration. But then the respondents, my lord, from their affidavit, because he was serving in the armed forces, their affidavit backs my stand saying that because He was under their service. The moment he goes missing, he has to be declared a deserter and an apprehension roll has to be issued. So the local police station has been informed, though we don't have a copy of the FIR. Local police, as far their affidavit, had been informed immediately that this particular person has gone missing.
That affidavit is where?
That affidavit.
No, the FIR?
FIR we don't have because they have informed, they say in
Who
their
has
affidavit
informed?
very clearly,
Who has informed?
the commandant of the unit.
Where?
My lord, would see page 73 of the affidavit filed by the union.
Yes.
Para 10. The deponent submits that after desertion of the petitioner's husband from unit lines on 2/7/1997, an apprehension roll was issued to the police authorities with information to the petitioner with a request to instruct her husband to resign duty forthwith.
Yes.
Then Lordship would come to the annexes.
After desertion of the petitioner's husband from unit lines on 2/9,
Hello.
was issued to the police authorities.
Now the procedure for deserters, my lord, is in annexes 16, page 53 in my writ petition.
Page?
Page 53, my lord, annexes 16
Yes.
in my writ petition, my lord. The letters of the police. This is the SOP for handling cases of desertion and people absent from duty. Your lordship comes down to page 56, serial 12. Upon desertion, my lord, the local civil police has to be informed by the commanding officer.
Just 1 second. Borrow. Nafala. बाकी उसमें को कोई दिखा यार थोड़ा अंदर कुछ बना ली बाबा ठीक है तो नंबर 2 इंश्योरेंस में कुछ अंदर पे इंश्योरेंस है yes
Lord, case 56, serial 12, desertion of AWL or a person
schedule
subject to the
12
serial 12, my lord.
yes
Serial
what is exactly that you want to show from here?
My lord, the SOP that is followed in the forces, the commandant immediately has to, if somebody is absent from duty, he has to also inform the local police.
So that has been done.
That has been done, and that is again confirmed, my lord, in the
Now,
page
if
83.
that is done, then what happens?
My contention, my lord, is that information, my lord, that has been given to the police that a particular person is missing is to be treated as an FIR. But more, basically, the FIR of a missing person is always that he is not available.
No,
he is not in
suppose
duty.
here it has not been done so. Then how are you aggrieved? I'm trying to understand
lord.
where exactly you're being aggrieved. I'm trying to understand the grievance because I understand the pension. Now only it's about the fixing of the date from which you would be entitled, right?
My lord.
Because the factum of the person going missing is not
My lord,
disputed.
not disputed.
You just give me the dates one, when did he go missing?
2nd of July, 1997.
2nd July 97.
97.
Missing.
My lord.
And then authorities. When did that letter you showed from that affidavit, the police authorities was informed
My
with a
lord,
copy to you?
that letter is also not annexed by them.
No, but
then that is made as a statement, my lord, in the.
where are these? You have, Miss Devi, you have these records.
No, Lordship.
I think it will be required.
This 3/7/1997 letter is not.
not an FIR lordship, apprehension.
No,
was-
but we need to know because now the this is Mr. Pathak is making these submissions.
Hello.
So which is where was that that page you just
Page
made?
73, my lord.
73.
We speak about a letter of 3/7/1997. That is however not part of the record.
Page 73. Yes.
The very next day.
Yes,
very
the very next day, this letter, 3/7/1997, this letter, then what happened?
Thereafter, they conducted a court of inquiry and said that he is missing, so he was dismissed from service.
You have this letter also.
Lordship, it is not annexed, lordship.
What I am trying to say that, my lord, moment a person, FIR is only information that a person has gone missing as far as the missing person is concerned. So this ultimately in the context of the case has to be treated as the information
See,
to
we
the
need,
police
you see,
that a person is
you see,
missing.
Mr. Pathak, now whether this is only an information like a GD entry
My lord,
or what, ultimately, unless we see this letter, we
lord.
cannot appreciate your argument.
my lord.
If
In
if
fact,
you want this court to appreciate your
understand.
argument, then this court will have to look into this letter.
My lord.
Correct.
They have to produce, my lord. They
So
have
then
stated
they
so
have
in
to
the affidavit.
produce. That is why I'm saying I can just stop here and do that right
My
now.
lord.
But if you want, if you are not, if you are saying that there are other things and you don't want to rely on this, then it's another thing. Then we may proceed with the
No,
hearing.
my case is
Correct.
based on this
So,
only.
so that then if you want to rely on this, then I have to see
My lord,
that
definitely,
letter,
definitely,
isn't it?
definitely. We ought to have actually since
They may ought to have actually annexed.
annexed it.
Heard Mr. B. Pathak, Learned Counsel, appearing for the petitioner. Also heard MS R. Devi, Learned CGI, Learned CGC. Stop. Mr. Pathak draws the attention of the court that though in the affidavit in
Page 73, para 10.
though in the affidavit filed, affidavit opposition filed on behalf of the respondents respondent numbers 1, 2, and 3 on 22/8/2023, in paragraph 10, it is averred that after desertion of the petitioner's husband from unit lines on 2/7/1997, an apprehension roll was issued to the police authorities with information to the petitioner with a request to instruct her husband to rejoin duty forthwith by letter number so and so dated 3/7/1997. It took page 37 of power. However, the same is not on record. Full stop. It is further pointed out that since the prayer or then since the grievance of the petitioner is not granting the family pension of the petitioner with effect from 2/7/1997, i.e., the date on which the husband of the petitioner went missing. And has instead been granted with effect from 10/1/2025, i.e.
2005.
2005, i.e. that is from
From the date of submitting the.
from the date of
lodging the
submission of
FIR.
the FIR,
With the wife.
by the petitioner, the same is essential to be looked. The same has bearing in the issue involved in the writ petition, in as much as the letter dated. The said letter dated 3/7/1997, whereby the respondent had inform the police authorities about the desertion of the petitioner's husband itself ought to have been treated as the first information report. That is his submission, Ms. Devi. You cannot control the submissions of the other side now. In order to essentially adjudicate in order to effectively adjudicate the issue involved in this writ petition, the said letter dated so and so ought to have been placed on record as reliance as the same has been averred in the ought to have been brought on record. Stop. MS so and so request a short accommodation to place the same by way of an affidavit.
Along with the court of inquiry, my lord. Because that will contain, the court of inquiry actually will contain all the records.
Relist when? After? Date, this is a pension matter, give a date. Relist on such and such date, on which date the affidavit, by which date the affidavit shall be filed, bringing on record the aforesaid letter, including the
Court of inquiry.
Court of
Court.
inquiry in the matter.
Number first.
Okay? Convenient?
Yes.
Convenient. Deputy.
Item 32.
Mr. Sharma, you've been waiting for which matter? There's still more to go. You want it on another date? No, you just inform the court master. Mr. Goswami is there in Sharma's matter? No. Yes, Mr. Paul, what is your matter?
My lord, this is a matter for dismissal of service of the petitioner.
Today, we filed the affidavit.
On behalf of the respondent number 5 and remaining respondents, those are main respondents, has prayed last 3 occasions for to file their affidavit, but they have not done so.
What is the issue?
To dismissal of service for misconduct.
Dismissal of
Service.
service.
And violation of Rule 9 of Disciplinary 1964.
Violation of Rule 9. That is a disagreement and all.
My lords, there is actually no inquiry, only in the name of inquiry, just he was present and subsequent after 2 days, an inquiry report was forwarded to the disciplinary authority. And
But
thereafter-
a last opportunity was given. So you have filed.
Yes, I filed the affidavit on behalf of Respondent 5, Lordship.
But affidavit of respondent number 5 is not so much
So
necessary.
who was given that
M. Bhattacharya was appearing.
So I think Mr. Goswami, you're appearing for the state
No, I am appearing on behalf of the state, Lordship.
and you have filed it on behalf of the state.
Yes,
the
Lordship. Yes,
affidavit.
Lordship. Yes, yes.
So that has, where is the affidavit?
Is it,
Yes,
is it
I
filed
think
today
Today,
morning?
Lordship.
Oh, it's filed today. It's not on record.
Yes, Lordship.
Whether you would not
I
file
have-
any other affidavit?
So then, Mr. Goswami, I'll have to let the registry place it on record. It has to go
Next day.
to another date.
Whether it is a
Lordship,
final
uh,
affidavit or
just
any
a
other
minute.
affidavit?
Lordship,
Mr. Counsel, please unnecessarily don't indulge in all these conversations. They file an affidavit, it is not placed in the court. Now we can't ask what is this affidavit and all that. Yes, why have a copy not been served upon the other side?
I served, Lordship.
sir.
Copy, sir.
Okay, yes.
Lordship, in the meantime, Lordship, for other respondent, Lordship, may I submit the affidavit, Lordship, for other
That you
respondent?
have not done till now.
Yeah, not done till now.
For
but,
whom you have to do?
Lordship, it is respondent 5, Lordship.
The 24 matter,
Yes, Lordship.
disciplinary proceedings.
Yes, Lordship.
But you see, whatever you have to do, you do it. What is the point
The
of
next
giving
date,
last
Lordship.
opportunity?
I'm
It-
appearing today itself.
No worries, since you've already filed one, I shall accommodate you,
Lord.
but then it's a 20,
Lord, sir.
I mean,
Kindly.
matter is of 24, but
Lord,
then the orders are saying last opportunity, so that has to be respected.
Lord, sir, I may be able.
Heard Mr. A. Paul, learned counsel appearing for the petitioner, also heard Mr. J.K. Goswami, learned additional senior government advocate for the state respondent. Mr. Goswami submits that an affidavit in opposition has been filed on behalf of the respondent number 5, and a copy of the same has also been furnished upon the learned counsel appearing for the petitioner. Mr. A. Paul, learned counsel for the petitioner, submits that he has received the same. However, the same is not placed on record. Let registry verify and place the said affidavit in opposition on record. Stop. In the meantime, and relist after,
Third week of November, any day.
give a date, relist on such and such date.
Can it be 4 week, Lord?
In the meantime, the respondents in the meantime, the remaining respondents shall also complete their return positively as earlier directed by this court by order dated 19/8/2025.
Item 33.
Yes.
I don't actually in another bench, special bench for NSA matter, my lord.
Oh, special bench is going on.
At 3 p.m. it was fixed, my lord.
Okay, no
We have
problem.
prepared for the 11th of November.
11 November, Chalia. MSP Bora, learned counsel appearing for the petitioner, submits that the arguing counsel, Mr. S. Borthakur, is on legs before the special bench which has been constituted today at 3 p.m., which is currently going on. Mr. Chalia for 23 Fukan for JD. Relist when?
11th of November.
Paribo 11th? আচ্ছা, বেলেগ এদিন কৰিলে। Relist on such and such. Release next week.
Next week, Lordship.
Huh?
Not 11th, Lordship. Next week.
13th.
18th.
All right, now 47, I think. 47.
Please, Lordship. My senior lake another court, Lordship.
Ah.
Lordship, next week any date, Lordship.
All right, as prayed for by MS J. Akhtar. Are you,
Diploma.
your J. Akhtar? Relist on after a week on a date to be fixed by the registry.
Lordship,
It'll come, Mr. Akhtar and J.K. Goswami. You are also there in
Yes,
this month?
47. Item 47.
Sorry, Lordship. I was in that in another.
You
We have a short issue in this case, Lordship. The petitioner Lordship has been dismissed from service without initiating, my lord, the departmental proceeding. And exercise has been, Lordship, done that under Article 311(2)(b).
no inquiry.
Inquiry was done, Lord.
No, that is not the departmental inquiry. That was the preliminary inquiry regarding, Lordship, the allegation that a case has
Fact
been.
finding.
Yes, Lordship, fact finding. That has been, Lordship, reflected in the order itself. If your Lordship kindly come to page 28 is the impugn order.
28.
May I read the?
Yes.
The complaint so and so of North Bongaigaon, under Bongaigaon so and so. lodged an
28,
FIR
page 20 or 28.
28.
Yes. Yes,
Whereas
yes.
complainant so and so, Lordship, resident of so and so, lost an FIR on so and so at Bongaigaon police station on 15/9/24. Her 11 years old daughter was sexually assaulted by one so and so, Torun Gogoi. He is the petitioner, Lordship. Posted at North Bongaigaon PP while victim was alone at the home. The said so and so Torun Gogoi allegedly put the complainant daughter.
Senior government advocate for the state respondents.
Lordship.
The state respondents.
Next part.
Mr.
Yes, 30.
It appears that the service of the petitioner was dismissed without holding any disciplinary inquiry. In view of the order of this court, in the case of Madhav Gogoi versus State of Assam, WPC 4212/2020. Stop. Mr. Chair Goswami so and so seeks seeks a short accommodation to look into the aforesaid decision and place in order to effectively assess the court. Prayer is allowed, relist when? After? Next week, a lot of matters got fixed. The week next. Dial over date to date. All right.
26.
Okay.
Obliged.